Through you, Justice Matlanga, Zunaid, if you could just proceed. Everybody's in, am I right? Yeah, I see you. I see you say. Yeah, Justice Matlanga, everybody's in. Thank you.
Thank you very much, brother. Yes, Mr. Tunga.
Good morning. I am the registrar clerk for this hearing. Justices of the Constitution.
Let me apologize. I'm very particular with names, mine included. I want to apologize most profusely. I cannot commit this crime. I will call your name again and try to do it properly. Miss Chitengu. My apologies. My apologies.
Not a problem.
Thank you.
Good morning. I am the registrar clerk for this hearing. Justices of the Constitutional Court, all counsel are online. I call the matter of Relebohile, Cecilia, Rafoneke, and others, and the Minister of Justice and Correctional Services and others. Counsel are invited to place themselves on record. Please note that this hearing is being recorded.
Counsel.
May it please the court, Justices of the Constitutional Court, I, together with my colleague, Mr. Chaka, appear for the applicants in the Rafoneke matter, case number CCT 315 and CCT 321 of 2021.
Thank you, Mr. Mazibuko.
Justices, good morning. I appear for the applicants in CCT 06-22, that's the Chakanyuka matter, together with my learned friends, Mr. Brickhill and Mr. Mafukidze.
Thank you, Mr. Badlenda.
As the court pleases, Justices. I appear on behalf of the fifth intervening party. My name is Rita Richards and I'm from the Johannesburg Bar.
Thank you, Ms. Richards.
Justices, I appear for the third amicus, together with my learned junior, Mr. Spello Bake.
Thank you, Mr. Skakani. Where's, oh, yes.
Chris McConaughey for the first amicus curiae, the Scalabrini Center, together with Amara Kachalia.
Thank you, Mr. McConaughey.
Justices Tabang Powe appearing for the International Commission of Jurists, the second amicus in the Rafoneke matter.
Thank you, Mr. Powe. Thank you, Ms. Powe.
Justice Matlanga, I'm not sure if all counsel are on record. I just want to check. There is a Tererai Mafukidze in the waiting room. Do any of counsel know who that is? Should we admit? And could Mr. Naidu, could you please admit Mrs. Kachalia and Mr. Brickhill? They are part of the case, please. Tererai Mafukidze.
That is my junior, Justice Majid, one of my juniors.
Yes. Please admit all of them, Mr. Naidu. Thank you, Mr. Matlanga. Thank you, Justice Matlanga.
Thank you, my brother. Ms. Moroka. Where's Ms. Moroka for the minister? Mr. Snellenberg.
Please, the court, Justices, I appear on behalf of the LPC, together with my learned colleagues, Ms. Makakati and Ms. Pakama.
Thank you, Mr. Snellenberg.
Apologies, Justice. I was struggling to unmute. I appear on behalf of the first respondent, together with my juniors, Ms. Mutwana and Ms. Matsile.
Thank you, Ms. Moroka. May I ask that you should please have only one device on where you are, not just muting, just it should be completely off. The second device should, because there's usually feedback if there's more than one within the same space.
I think she was trying to help me with my technological challenges, Justice, because I was struggling to unmute. My apologies.
No problem at all, Ms. Moroka. Thank you very much. I think we have all counsel now. Yes, Mr. What I forgot, counsel, when I was meeting with you earlier, was the question of replies. I'm giving Mr. Mazibuko and Mr. Badlander 10 minutes each. And Ms. Richards, it will only be if you feel there's something really pressing that you want to reply to. And I will give you only 5 minutes. But otherwise, there's no reply for you. So it's 10 minutes for Mr. Mazibuko and Mr. Badlander.
That's in order. Thank you, Justice.
Thank you very much. Mr. Mazibuko.
Thank you, Justice Madlanga. As justices would have noted, the origin of this matter is the order of the Free State High Court declaring as unconstitutional and invalid the provisions of Section 24(2) of the Legal Practice Act to the extent that it precludes foreign nationals from being admitted and enrolled as non-practicing legal practitioners. Now that order serves before this court for confirmation. However, as it appears from the notice of appeal filed by the applicants, they are not content with the extent of the order of invalidity. The applicant's case before the High Court and before this court is that Section 24, subsection 2B of the Legal Practice Act is unconstitutional and invalid to the extent that it precludes foreign nationals from being admitted as legal practitioners, be it practicing or non-practicing. Now, justices should have noted in our heads of argument that the structure that we adopt in advancing our argument is in line with the cascading test in Huxon versus Lane test. In broad terms, we will submit that the High Court erred in finding that the impugned provisions have a legitimate government purpose and as such do not violate Section 9(1) of the Constitution. And we will also submit that the High Court also erred in finding that the impugned provisions do not unfairly discriminate against the applicants. Now, we will submit that the differentiation harbored by the impugned provisions, and we say it is Section 24(2)(b) of the Act as well as Section 115. When they are read together, they differentiate firstly between citizens and permanent residents on the one hand and all other foreign nationals on the other. And secondly, between foreign nationals who have been admitted in designated foreign jurisdictions on the one hand and all other foreign nationals. And we submit that that was accepted by the High Court and that was not disputed by the respondents before the High Court, that such differentiation exists. The minister has submitted that there is a legitimate government purpose to the impugned provisions. And the court will find that in the affidavit of the minister in volume 3 of the record from page 204 at paragraph 36, the minister says the purpose of the impugned provisions is for government to ensure that foreigners who have obtained their qualifications in law and apply to be admitted and enrolled as legal practitioners do so after having followed the proper legal channels which permit their employment in South Africa. So that is the first express purpose that is stated by the minister for the impugned provisions. And then it is also discernible from the affidavit of the minister also on page 204 of the same volume and 205, that the minister suggests that the impugned provisions are also aimed at maximizing opportunities for aspirant South African graduates to enter the legal profession. Also discernible from the affidavit of the minister is the suggestion that the impugned provisions are also aimed at protecting the public against embezzlement of funds and other prejudices to clients. We submit that those are the three discernible purposes that the minister has advanced for the impugned provisions. The High Court accepted that indeed those were the purposes of the impugned provisions. We will also submit that the High Court went further and found that there are other purposes to the impugned provisions. For instance, the High Court found that the purpose of these impugned provisions is for government to comply with its obligations under, that is international obligations under the General Trade Agreement, that is the GATS agreement. In our submissions, we say the purpose that is stated by the minister is not the purpose of the impugned provisions. If it is, we submit in the alternative that it is not a legitimate purpose, and we submit in the further alternative that if it is a legitimate purpose, then there is no rational connection between the impugned provisions and the stated purpose. And on the sum of those submissions, we say the impugned provisions violate section 9(1) of the Constitution and should for that reason alone be declared unconstitutional and invalid. And we further submit that even if it were to be found that there is a legitimate purpose to the impugned provisions, those provisions still unfairly discriminate against the applicants on the grounds of nationality or citizenship. Those provisions have an unfair impact on the applicants and impair their dignity. The impugned provisions subject the applicants to systemic disadvantage, and that unfair discrimination we submit is not justifiable under section 36 of the Constitution. Now, if I may just start with the first purpose that is advanced by the minister, and as I address the minister's justification, I will to an extent also refer to the findings of the High Court relevant to the purposes as stated by the minister, and at a later stage also highlight the applicant's discontent and the errors which we respectfully submit were made by the High Court in its approach to this matter. Now, when one is looking for a purpose of a specific legislative provision, and then the entire scheme of the legislation becomes helpful, and in particular, the objects of the legislation as stated in the relevant legislation. Now, our submission is that when one has regard to Section 3 of the Legal Practice Act, which sets out the objects of the Act, the Act is not concerned with regulating the employment of people, be it South African citizens or foreign nationals. Rather, the Act is concerned with the regulation of the practice of law by legal practitioners. It regulates the admission and enrollment of legal practitioners, not the admission and enrollment and employment of legal practitioners. Now, if we look at the first stated purpose by the minister says the purpose of the impugned provisions is to ensure that persons who have obtained their qualifications and apply to be admitted do so after having followed proper legal channels which permit their employment in the Republic. The impugned provisions do not anywhere refer to employment, but in any event, the minister does not explain what these proper legal channels are. For instance, Ms. Rafoneke is the holder of a Lesotho exemption permit, the conditions of which
Mr. Mazibuko, the 10 minutes is up. Please do continue. My colleagues may put questions to you.
Thank you, Justice Matlana. Yes, I was saying Ms. Rafoneke is a holder of a permit which allows her to be employed. Now, if we take the stated purpose by the minister, does it mean that she, by virtue of the fact that she is legally in the Republic and has a permit which allows her to be employed, she can be admitted?
Mr. Mazibuko, could I ask you, please, the permit that allows it to be employed, does it allow it to be employed in any sector? Is it a permit issued without conditions, or is it confined to employment within a particular sector or within a particular form of employment? And if she should change her employment, would she be required to change the terms and conditions of her permit?
I've had regard to her permit, Justice Colapen, and I see it does not specify particularly that she should be employed in a particular sector. I'm just getting to the relevant part of the report where that permit is attached. It is in volume 3. And right at the back of the volume on page 273. And when I look at the conditions of the permit, it says the LEP permit entitles the holder to conduct work/employment. So it does not say that it is confined to the legal sector, for instance, or the construction center, for instance. It appears to me that it is work in general that is permitted in terms of that permit. Now, but there is a fundamental problem with the purpose as stated by the minister. We make a point in our heads of argument, and that is the point that is made by the applicants in the founding affidavit and in their replying affidavit in the matter.
Mr. Masbuo, excuse me,
Justice
still on the permit issue. My understanding of the minister's argument is that some of the applicants are on a study visa or permit.
Yes.
And that will mean that one is here for purposes of study only. Once you are employed, you are supposed to apply for a visa in terms of Section 19 of the Immigration Act, right, with the regulations there too. So what do you say to that? And ordinarily, as a foreigner, we know that you'll have to apply for a visa for purposes of employment whilst outside of the country. So my understanding of the argument is that now if you are coming up with this argument, you are trying to avoid having to apply for the other visa, the work visa.
Yes. Justice Mtlanka, my answer to that will be this. Firstly, my understanding of the minister's argument is that if you've entered the country on a study visa and you later want to be admitted, and then you would have circumvented the immigration processes by not applying for the correct visa. But those are not the facts in this matter, because we know that Rafoneke and Tunyani came in as students, obviously, via a study visa. But a person cannot be confined to a study visa. Once that visa has satisfied its purpose and a person wants to remain in the country for an extended time and to be employed here, ordinarily and by law, they should apply for the relevant permits. If we look at Tunyani, for instance, we can't confine him to a study visa. He's now married to a South African citizen and has a spousal visa, which is also endorsed with a work permit. So in my respectful submission, there is no merit in that argument to say, if I entered the Republic with a study visa, I cannot obtain any other visa if I want to work in the Republic and stay in the Republic in future. So
now in this particular situation, say one is allowed to apply for admission and be admitted, what would be the route to be taken by the applicants? Would they, at what stage would they apply for a visa, or what would happen?
Yes, our submissions in this regard, Justice Mhlantla, is that admission and employment are separate and distinct. Although if I want to be employed as an attorney, for instance, at a firm, I obviously have to comply with the immigration laws. I need to have a work permit. But our submissions are that for admission purposes, a work permit is not a necessity. If I approach court and I want to be admitted as a legal practitioner, the inquiry should be whether or not I am properly qualified and if I am fit and proper to be admitted as a legal practitioner. And once the court licenses me, if I use that word loosely, and then I want to approach a firm of attorneys to be employed, and then I need to apply for a work visa. And we know that my hurdles do not end there, because my employer still has other requirements in terms of the Immigration Act and in terms of the Employment Services Act to comply with for me to be employed. It does not follow, and that is what the High Court found. The High Court found that if I admit a person as a legal practitioner, I permit them to practice, and without more, I allow them to be employed. We say that is not the case, because even if I have my admission certificate today, I need a work visa, because if I work without a work visa, then I am contravening the law. If I am resident in the Republic, I need a permit that will keep me in the Republic, because if I don't have that permit, then I am in the Republic illegally. And when we buttress this point, we take an analogy of persons admitted in designated countries. If one looks at Section 5 of the Admission of Advocates Act and Section 17 of the Attorneys Act, they permitted persons from designated countries to be admitted in the Republic if those persons satisfied the court that they were admitted there and they were ordinarily resident there and they did not have any pending proceedings to have them struck off the roll. The issue of their status did not arise. In other words, once they are admitted here, they can go back, and if there are circumstances that require them to appear in the Republic, they can come subject to compliance with other requirements that will permit them to be in the Republic at the time, be it a visitor's permit or a temporary visa of sort.
So what you're saying is these are two different processes, basically, and we must not concern ourselves with what will happen under the Immigration Act or the Employment Services Act.
That is so, Justice Mhlanga, and I say that because if one has regard to the affidavit of the Minister of Home Affairs, for instance, and the Minister of Labor, they explain in detail the processes that are involved for persons to firstly enter the Republic, for persons to get a work permit, and for persons to be employed. And we know that employers must do a diligent search first to see if they can employ South Africans first, and then if they can't find a suitable South African, and then a foreigner will then be afforded an opportunity. So our submissions are that these are two distinct processes. For the court to admit a person, we all know that it also involves a value judgment. The court says you are properly qualified. Let me look at your character. Can you be amongst the rank of legal practitioners? And if I'm satisfied with that, and then I admit you because we can rely on your word as a legal practitioner, we believe that you can serve the public well. And
thank you, Justice Madam.
Advocate Mazibuko.
Sorry to interrupt, my brother. Sorry, Justice Matlanga. There are two persons in the waiting room. I'm sorry, they came in late. A person called Sharon and a person called Basetsana Molebatsi. Can counsel perhaps help us here? Sharon and Basetsana Molebatsi. Should we admit them? Does anybody know them?
Yes, Justice Majid, Ms. Molebatsi is my instructing attorney. Yes, I know her.
Thank you. And Sharon, anybody? Thank you, Mr. Skakani.
Thank you.
Right. Nobody knows. Thank you, Justice Matlanga. I'm sorry for the interruption. Thank you.
Not at all, my brother, by all means. Yes, my brother, Justice Matopo.
It was myself. My baritone is not.
I'm so sorry. I'm so sorry, my brother.
Thank you. Advocate Mazibuko, I just want to take you to a different aspect.
Yes,
Section 22 of the Constitution mentions two things that I want to debate with you. One is it says every citizen has the right to choose their trade, occupation, or profession freely. And then it says the practice of a trade, occupation, or profession may be regulated by law. So there's a deliberate mention of citizen in this section of the Constitution. I'm sure I can see you nodding, so we're at one there. And then, yeah, and then what I want to check with you is the regulation by law that's mentioned there. Doesn't the LPA fit that bill? That it's one of those laws that is contemplated in that section.
It is. I agree with you on those two propositions, Justice Blambo. Yes. And let me start with the last mentioned one and then revert to the main one relating to the rights of citizens to choose trade. It is so that the Act regulates the profession. And when the Act regulates the profession, just like any other law, it should ensure that it does so in a manner that is consonant with the Constitution itself. And we submit that the right that is being asserted by the applicants in this case is the right to equality and not to be unfairly discriminated against. And I will accept, as I should, that when rights are being dealt with and they are being interpreted, the court must do so looking at them all together, and it is not an isolated exercise. For instance, when the court looks at the applicant's case in this matter, the court should have regard to Section 22. But Section 22 affords a citizen the right to choose trade. And if the applicants in this matter are admitted as legal practitioners, on subsection 1 of Section 22, I submit that admission of the applicant as legal practitioners will not do any violence to Section 22. Yes. Yeah, and we say even though the Act also refers to Section 22, it gives effect to Section 22 because it needs to regulate trade, but it must do so in a manner consistent with the Constitution. It should not do so in an arbitrary manner, or it should not manifest naked preferences.
Yeah.
And our submission is that one naked preference that is manifested by the Act is borne out in the different treatment of foreigners who are not permanent residents, who have studied in our country, have done their practical vocational training, have written the competency-based exams but cannot be admitted. But on the other hand, it allows foreigners in the same position who are merely admitted in foreign jurisdictions to be admitted in the Republic as legal practitioners.
Yeah,
so
let me stop here. I'm sorry to intrude.
Yes,
I think I understand that part, but I was just saying, if there's a deliberate mention of the word citizen in that section, and you see it in section 19, and you can see it in section 174 as well, as far as appointment to the Constitutional Court is concerned, but deliberately mentions citizen. But if you look at the other rights, like section 18, everyone has the right to freedom of association, everyone. Yes. Is there anything to section 22 specifically being couched in this way? I just wanted to check that.
Yes. My submissions, Justice Mlambo, as I said earlier, obviously the applicant cannot approach the court and seek to assert their rights in terms of section 22 because they do not have those rights. Section 22 is reserved for citizens. The right to choose vocation and trade is reserved for citizens. But that section, my submissions are that it is not a trump card to other rights, because the right that is being asserted here is the right to equality.
Yes.
And if we permit the applicants to be admitted, we are not taking away the citizens' rights to choose vocation. For instance, we are not taking away the South African law graduates' rights to choose to be legal practitioners. The Section 22 rights of citizens remain intact. So, although I accept that the court must have regard to Section 22 when it looks at this matter, but the rights of citizens will not be violated in any manner under Section 22.
Yeah, thank you, Advocate Mazibuko. Thank you, Justice Madlanga.
Mr. Mazibuko.
Justice Matopo.
I may have to take you back to the questions that were put to you by my sister, Justice Mhlanhla.
Yes,
somebody comes to the country on a study visa like Mrs. Rafoneke. I just want to understand you. For as long as that person is in the country by virtue of that study visa, say it's 2 years or 5 years, or within that period of time, he or she qualifies as a legal practitioner, attorney, or counsel. That person, in your understanding, notwithstanding how he came into the country, would qualify, or not qualify, would be entitled to approach a court after having completed the vocational trainings or pupillage articles to say, admit me because I am now, I do meet the requirements of being an attorney or an advocate. And I just want to understand your argument, notwithstanding that the person may not have been may not have a citizenship and may not have permanent residence.
That is the argument, Justice.
And if that person is now admitted in the as a practitioner, it is none of, I'll put it as high as that, it is none of our business as to what happens to that person. The LPC, or the case that is being mounted here, is that he or she must be admitted. And once he or she is admitted, as to what happens to that person thereafter is for the immigration officials, for the Minister of Labor, and everybody else to do what they want to do.
No, not precisely
I
in
just
those
want
terms.
I just want to understand that. Yeah.
Yes, not precisely in those terms, Justice Matupo. Let me say this because we also make a point. If the court admits a legal practitioner, I will use the word loosely, that legal practitioner becomes the subject of the court because the legal practitioner is accountable to the court. Bearing in mind that the court admitted the person because the court deemed the person to be fit and proper to practice. The Legal Practice Act must exercise regulatory authority over this person. The point that we were making.
Let me interrupt you to shorten the debate. That I understand. He or she would be admitted and subject to the rules and regulations of the LPC, right?
Yes.
And if that person has to choose, I'm going to use the word a trade or practice, how is that person going to practice? Or is it another area? It's not part of us now. Yes. It's a debate for another day.
We will submit that it is sort of a debate for another day, Justice Matupo. Let me say this. We are not saying once a person is admitted, they can do as they please. The point that we make is that just like any other foreign national, once a person is admitted, the person must comply with the necessary Immigration Act. The person must get a proper permit to be in the Republic if the person resides in the Republic. To work in the Republic, the person must get a work visa. To establish a business like a law firm, a person must get a business permit. Those are the requirements that the person must comply with. And if the person does not comply with those requirements, we know the Immigration Act criminalizes such conduct. And if the person has to be brought before court because they did not comply with the immigration laws, and then our criminal courts are well capable to deal with such matters. But for present purposes, the applicants want to become officers of the court and to be enrolled. And once that has happened, they will then have to do the necessary in terms of the immigration laws to be admitted.
Okay, now tell me, why would you then, if this is your submission, have a problem with the minister's submission in paragraph 36 of volume 3, the one that you have referred to us when you began your submission?
Yes, the problem that I have with that submission is that that submission seeks to justify the preclusion of foreign nationals from admission. That is the problem that we have, because when they approach court for admission for the first time, they do not ask the court to direct that they be employed in certain capacities or in certain law firms, or that they practice for their own account. They are merely saying we want to be amongst the ranks of legal practitioners, we want to be enrolled, and then whereafter all the necessary laws must be followed in relation to our employment.
Thank you.
Mr. Mazibuko.
Justice Winter-Walter.
I wanted to go back to my brother, Justice Mlambo's line of questioning. Do you accept that a foreign person has no right to occupational choice under our Constitution?
That is so, Justice Winter-Walter.
Well, why is it then discriminatory if the authorities choose to formulate legislation in such a way that they decide that certain occupations will be reserved for citizens, or primarily for citizens, in the case of this legislation, also for permanent residents? We may not think it's the wisest policy. We might have other ways of regulating our policies, but why is it discriminatory? A foreigner has no right to choose an occupation in South Africa. Why can't the government say this category of occupation is reserved for South Africans and as a special allowance for permanent residents? Why is that in any way illegitimate?
It becomes illegitimate when foreign nationals in the same category as that of the applicants are allowed to gain admission, whereas the
But I'm not clear why it's discriminatory. If it's permissible to reserve an occupation primarily for South African citizens and permanent residents, you can make certain carve-outs in respect of reciprocal arrangements under your trade agreements. It's just a carve-out, but it doesn't amount to discrimination. It's simply saying, if we're permitted to reserve this occupation for South African citizens, we can make a certain carve-out in respect of our trade, reciprocal trade relationships as part of our trade policy, but that's also a legitimate objective. So I'm struggling to see why any of this is illegitimate. It may not be desirable. There may be other ways of doing it, but why is it not a permissible object for government to pursue?
And the submission that I made earlier, and we derive this from the jurisprudence of this court, if it manifests naked preferences, then it cannot be legitimate.
But why is it? It's not arbitrary. It's saying we reserve for citizens because they have certain special claims upon our concern, certain occupations. And although we give foreigners certain rights, we don't give them all the rights. And among the rights we don't accord them is a right to occupational choice to pursue employment in a particular occupation in the country. I'm not clear why it's a naked preference.
It is a naked preference, Justice Hunter-Holter, because if you have someone who is admitted in the Kingdom of Lesotho, for instance, in a designated country, who did not study here, who did not do their competency exams here, eligible for admission as legal practitioners here, and then you have someone from Lesotho who also does not have the permanent resident status, but who studied here, who knows our laws, did the competency-based exams here, and in fact, was found to be fit and proper, excluded from admission. I submit that there cannot be a naked preference more than that.
No, thank you. I have heard your submission.
Thank you, Justice Hunter-Holter.
Mr. Mazibuko, can I follow up? Then now that my brother has finished.
Yes, Justice Tiki.
If someone who has been admitted outside of the country is able to be admitted or to be allowed to come and practice in South Africa, would an argument be made that it is not necessary to declare Section 24 unconstitutional because those foreign nationals can simply go back to their countries, get admitted there, and possibly establish practices there, then come back to the country and ask to practice here? Why is it necessary to strike down this legislation, bearing in mind that this legislation has to be looked together with Section 22, as you have been referred to?
Yes. Justice Tiki, let me start by saying this. We know now in terms of Section 24.3, the minister may make regulations pertaining to the admission of legal practitioners. Those regulations are not yet in place. That is the first issue. The second issue is that the persons in Lesotho who are entitled to be admitted in the Republic are so entitled because of Section 17 of the Attorneys Act and Section 5 of the Admission of Advocates Act. And those sections are to an extent kept alive by Section 115. But these applicants cannot benefit from Section 115 because on the date mentioned in Section 115, they were not legal practitioners who were admitted in foreign jurisdictions. So the discrimination remains as matters stand. But in any event,
is the discrimination pertaining to them only, or is it discrimination pertaining to everybody who has studied in South Africa, obtained their articles in South Africa, and then who then would go back to their country and get admitted there and ask to practice here? Does it pertain just to your clients, or is it discrimination to everybody in that situation?
My submissions will be that it is discrimination to everyone in that situation, Justice Chiki.
In your client's situation?
Yes.
No. What I'm trying to debate with you, Mr. Mazibuko, is from your response. You said that your clients would not benefit from going back to their countries and then coming back, get admitted and then coming back here. So when I say is it discrimination generally, I'm saying, does it discriminate against all foreign nationals who actually want to practice in South Africa?
Before you respond,
yes,
Mr. Mazibuko, your 40 minutes is up. How much more time do you want?
Justice Madlanga, if I can just make, I can just respond, and then I just want to make one more point. Perhaps 5 minutes may suffice.
Five minutes,
yes.
Or including your response to my sister, Justice Chitku.
Yes, Justice Madlanga.
So 5 minutes all told. All right, please continue then.
Thank you. Justice Chiki, if I understand you correctly, you are asking if the discrimination pertains only to the persons in the category of my clients or to all foreign nationals in general. Obviously, it affects my clients. It pertains to them. The foreign nationals who are admitted in their foreign jurisdictions do not have the same problems if they can benefit from Section 115, because they are not precluded by the legislation from being admitted in the Republic.
I think that why at cross purposes, let me try again. Maybe I'm not being very clear to you. I'm saying, suppose a foreign national is permitted to come to South Africa to study here. They study here, they qualify, they do their articles here. And then after doing their articles here, they go back to their countries, get admitted there, and then come back and ask to practice here. So I just want a general submission, not specifically taking into account the factual considerations of your client. I'm trying to test whether this legislation is discriminatory across the board, or is it discriminatory just because of the specific facts of your client?
Well, my submissions are that it is discriminatory across the board to foreigners who are not permanent residents, firstly, and to foreigners who are not admitted in designated foreign jurisdictions before the date set out in Section 115.
Thank you.
Thank you.
Justice Madlanga, I have a further question, if I may. Mr. Mzibuko, I just want to check, Mr. Chunyane, the second applicant, he is here on a spousal visit, a spousal visa now, is that correct?
That is so, Justice Majid.
and he would have qualified for permanent residency in 2020. Is that also correct?
If I'm not mistaken, it was last year, 2021, Justice Majid, but as matters stand, he qualifies to apply.
Yes, well, it doesn't matter. Last year or the year before, as matters stand, he does qualify. Has he applied for permanent residency, and if so, has it been granted?
Justice Majid, I say this, obviously, it's not in the papers yet, but he has informed me that he has applied, but it has not been granted.
Yes.
My understanding is that it's quite a process, but it has not been granted yet.
Yes. Now, when the applicants, Ms. Rafoneke and Mr. Chinywane, registered their articles, when they did their vocational training, up until the time when they applied for admission, they either knew what Section 24 of the Act said, or I would suggest they ought to have known, because they were hoping to practice as admitted attorneys in the Republic. Not so?
That is so, Justice Majid.
So they would have been aware not only of Section 24, but also of Section 22, which has been canvassed by some of my colleagues with you, that the choice of a profession or trade or occupation is restricted to citizens. And the impact of those two sections, Section 22 and Section 24.2 of the LPA, would have caused them to realize that they would at some stage have to apply for permanent residency or South African citizenship ultimately, not so?
That may be so, Justice Majid.
But your argument is that is wholly irrelevant, because we must only see whether there is discrimination or whether there is no legitimate purpose to the impugned provision.
Yes. Then my argument, Justice Majid,
please continue. Yes.
Yes. Firstly, the applicants do not ground their case on legitimate expectation. That is the first issue. And secondly, we cannot argue responsibly that Section 22 is wholly irrelevant. Obviously, when you consider Section 9, you look at other constitutional provisions and you interpret them together. However, as I submitted earlier, Section 22 is not a trump card. If the government regulates profession, it is entitled to do so by the Constitution and by the enabling laws like the Legal Practice Act. But when it does so, it must still do so in a manner that is consistent with the Constitution. In other words, when it regulates profession, it should not unfairly discriminate against persons. And our case here is that although the government is entitled and it does regulate profession by way of the Legal Practice Act, it does so in a manner that unfairly discriminates. And it need not be intentional for the government to discriminate. Even if it happens inadvertently, it remains discrimination. Yeah. So that is our case.
Yes, I have that submission of yours. Thank you. Lastly, just to clarify Ms. Rafoneke's position. She was here on a study visa. What is the position now? We've clarified Mr. Chinywane's position. Yeah. What is Ms. Rafoneke's position now? As we speak?
She's now here on a permit called the Lesotho exemption permit.
Oh, she's on the LEP. Yes.
Yes.
No, thank you.
Yes. LEP, it expires in December of 2023.
That's right. Thank you. Thank you, Justice Madlanga. Thank you, Mr. Masbuku.
Justice Madlanga, I'm sorry. There's something else I wish to pose you with Mr. Mazibuko. Mr. Mazibuko, can you just assist me? I'm going to take you to the provisions of Section 26. My understanding of Section 26 of the Immigration Act, as I understand it, in terms of those provisions, if someone is a holder of a work permit and has received an offer for permanent employment, that counts a lot onto whether that person is able to get a permanent residence permit. Am I correct in my understanding?
That is so, Justice.
Would it be fair if someone said that this attack on the provisions of Section 24 is meant to circumvent the provisions of Section 26 in the sense that if one gets admitted, because this court has said that Section 24 is unconstitutional, and that person manages to get permanent employment in a law firm or wherever, then that would count in that person's favor.
Towards permanent residence.
Yes.
Yes. No.
And as I said, my question is testing whether there's any substance to an allegation or a submission that this whole application is meant to circumvent the provisions of that provision.
I understand that, Justice Tiki, but our submissions will be that there is no substance in that allegation. I mean, the process follows the law as it should. If it later on gives an advantage to the person, it does. But the reality of the matter is that for a foreigner to even get an offer of permanent employment is no mean task. If one has regard to the affidavit of the Minister of Home Affairs and the Minister of Justice, if one has to Regulation 18 of the Immigration Act and the Employment Services Act, which requires that South Africans must be given preference over foreigners. So our submissions is that there is no merit with respect in that proposition that that will in any way be circumventing the provisions of the Immigration Act. The process is there. It is cast in stone. All foreigners have to follow it.
But you do agree that it would be an added advantage, and it would actually weigh heavily if that was the case.
Yes, it is also an advantage to a South African. If I'm admitted as a legal practitioner, then I have an advantage over my counterparts in any competition for employment. I mean, if a person gets admitted, it is an advantage. I must accept that, Justice Tiki. But we submit that it does not follow that that will be advancing the circumvention of the immigration laws.
Well, I'm putting that position because I mean South Africans they don't have any kind of hindrance, but in your case, you get admitted, you manage to declare a law that says that you may not be admitted, and because that law has been declared unconstitutional, you then get that added advantage. That's the only point I'm submitting to you. So, which is why I have a problem when you compare non-South Africans to South Africans in that scenario.
Yes, Justice Tishi, I will stand by my submission that even if that advantage is there, it does not follow that the law will not be followed. If a foreigner wants to be employed, employers must still follow the Immigration Act and the Employment Services Act. But I cannot gainsay the fact that there will be an advantage to an extent. But that advantage would have been obtained in accordance with the law.
Thank you, Justice Madlang.
Mr. Mazibuko.
Thank you, Justice.
There was something additional you said you wanted to touch on after responding to Justice Chiki, and there was an additional question from another colleague of mine. So I'm sure you still want time to touch on the other point.
Yes.
Probably 3 minutes. Probably 3 minutes only now. Is it not?
I think if I might have exhausted the whole 5 minutes, Justice Matang.
You have. You
Yes.
have. But no. I want to be fair to you because the 5 minutes was used up by responding to my colleagues, and yet you had indicated upfront that you wanted to touch on something else. So
yes,
if you want to, please, by all means, please do. But how much time do you want? 3 minutes?
Can I try my luck and go to 5 minutes if you allow
All
me?
right,
Justice
all right.
Madlanga?
Yes.
Thank
yes.
you. Thank you. Justice Madlanga, the engagement so far have revolved around the first purpose that is stated by the minister for the impugned provisions that they are aimed at ensuring that persons who apply to be admitted have the necessary permits that allow them to work in the Republic. But the other purpose by the minister, and that appears also in the argument, in the heads of argument of the minister, is that the section is aimed at optimizing opportunities for aspirant legal practitioners to enter into the legal profession. But if that is the purpose, the question that begs is, why is it that the preceding legislation and this act, the Legal Practice Act, do not preclude foreigners from undergoing practical vocational training? Because by allowing foreigners to undergo that training, it should follow that then the opportunities of South Africans are limited. Then we therefore submit that that cannot be the purpose of the legislation if one has regard to the fact that foreign nationals are able to undergo practical vocational training without any hindrance in the act. But besides that, the minister seems to be relying on the views of the LSSA for that proposition. It does not appear to be the purpose that is asserted confidently by the minister to be the purpose of the legislation, but we submit that cannot be the purpose of the legislation. And furthermore, the minister, as the last proposition, seems to suggest that the legislation is also aimed at protecting the public from unscrupulous legal practitioners, if we can put it that way. But a general proposition that foreigners are less trustworthy cannot hold. The same safeguards in the Legal Practice Act vis-a-vis South Africans and permanent residents should and can find application to foreign nationals once they are admitted, and so are the other regulatory provisions in the Legal Practice Act. And I must make one point insofar as that is concerned, that if one looks at Ms. Rafoneke and Zinyani, these are the people who had completed their articles, have done everything. They have appeared before our lower courts. And a blanket suggestion that they may not be trustworthy cannot justify the preclusion.
Mr. Mazibuko, I didn't understand the minister's argument to be saying that they are not trustworthy because they may be corrupt. My understanding of the submissions was that if the permit were to lapse or it is not renewed, it would mean that that particular foreign attorney would have to go back to his or her country, which will mean that if that attorney were involved in a particular matter that is not yet finalized, the clients will be prejudiced. That is my understanding of the argument.
Yes, in fact, that is the finding of the Free State High Court. That is the peril that might face clients if the permit lapse. But by way of analogy, if one looks at a permanent resident permit, it is not a permit that is irrevocable. For instance, if a person who has a permanent residence permit is convicted with a Schedule 1 offense, that is in terms of the schedules of the Immigration Act, offenses like murder, or even where it is an assault where a dangerous wound has been inflicted, within 1 year of the issuing of the permit, it may be revoked, and the same result would follow. If a person has a permanent residence permit, it has certain conditions which, if not complied with, and then the permit is revoked, the same result follow. But that same result follows even for South Africans who are employed in law firms, and they cease to be employed there, they have a trial set down. A few months later, someone else will unfortunately have to take over the files and proceed with the matters. And unfortunately, the same result follows where the court suspends a legal practitioner and files are taken over by the regulatory body to ensure that clients are not prejudiced. So it is a live possibility, but our submissions is that it is not enough to insulate the impugned provisions from constitutional invalidity. Yes.
This must be the terminal point, Mr. Mazibuko.
Thank you, Justice Madlanga. We will just say if the court is with us, obviously, the primary relief that we seek, we will request that be the relief granted.
Thank you very much, Mr. Mazibuko. Mr. Badlen.
Thank you.
Good morning, Justice Madlanga, members of the court. Justice Madlanga, we have listened carefully to the debate between the judges and my learned friend. And in those circumstances, we can sharpen our submission somewhat to focus on some of the issues which are of concern to the court. I propose to deal in the course of this address with the following issues. Firstly, I will deal with the question of direct access very briefly. Then I wish to deal with the nature of the people affected, the position they occupy, and whether it's accurate to call them temporary residents and what that means. Then thirdly, I wish to deal with Section 22 of the Constitution and the concerns that members of the court have raised regarding its effect. Fourthly, I wish to deal with the Union of Refugee Women case. And finally, I wish to emphasize the absence of any proper purpose in this regard that has been laid out by the minister or the LPC. But at the beginning, I need to make certain overarching points, if I may. And this court will know that we approach the court on the basis of a double challenge. We seek to contend that the provisions are unconstitutional as breaching the right to equality because they constitute unfair discrimination. And we seek, and in any event, to contend that they breach the right to human dignity. And when we consider the response that our learned friends have given in their heads of argument and in their papers, it seems to us with respect that there are four fundamental difficulties with their approach. The first fundamental difficulty is that they do not seem to appreciate that the challenge, at least as far as my applicants are concerned, and it might be that there's a slightly different approach in the Rafoneke case, but in the case of my applicants, it is only a challenge that contends for the right to admission of people who already have the right to live and work in South Africa. So the distinction which my learned friend draws between the right to work on the one hand and the right to practice on the other, or be admitted on the other, is extremely sharp and it's extremely pertinent. We do not seek to contend, and let me be unequivocal. We do not seek to contend that the mere fact that someone has studied here and completed an LLB is sufficient to justify them to bring a constitutional challenge, to strike down the act and say, but I've then got a right to be admitted. There may well be an argument for that. I'm not saying that argument is not good. I'm simply saying that is not the case of my clients. My clients have a much more narrow and focused attack, which says, where the government admits people into the country and gives them the right to live and work, the government may not then say, you are precluded from practicing as a lawyer. You can go and work for Anglo-American as an internal legal advisor. You can go and work for the Gauteng provincial government as an internal legal advisor, but you cannot have the status of an attorney or an advocate unless they have a cogent reason for that. And I'm going to come back to the cogent reason and the absence of it. But that point is fundamental because it goes to the question of remedy, it goes to the question of less restrictive means, and it goes to whether this has been justified at all. And what it also means, of course, is that many of the arguments that are advanced by the other side, with great respect, go nowhere. Because we're not talking about opening the floodgates to everyone who studies in South Africa. We're not talking about opening the floodgates to everyone who is illegally in South Africa. We are talking about people who are legally in the country, who already have a right to work, who are duly qualified, who are fit and proper, and would undoubtedly classify for admission, but for this provision. And the question is, has the government or the respondents put up a legitimate basis for excluding those people from the right to admission, that narrow category of person? And we submit not. The second point is that it is tempting in a case like this to get drawn into the individual facts of an individual applicant. But that, of course, and our learned friends for the respondents engage in long debates about the ZEP permit and what it means. But with great respect, that's neither here nor there, because we are dealing here, as this court knows, with objective constitutional invalidity. And objective constitutional invalidity means we must look at the principle and the class of people it affects. It's that narrow class that I've sketched, but debating whether this applicant or that applicant could or shouldn't have applied for permanent residence doesn't really assist. But insofar as it matters, let me say, my clients, all three of the applicants, have all been here in excess of 10 years. They are all here lawfully. They all have the right to work, and none of them is yet qualified to apply for permanent residence because of their circumstances. Indeed, some of them have actually tried, as the papers make clear. And some of them are here as a consequence of the ZEP permit. Those are the first two, and the third is a spouse of a South African. So they all have a right to work, and it's an unlimited right to work in answer to the question that's put. It's not limited to a specific company or a specific person, and yet they are precluded from being admitted. The third point I make, and it is with respect fundamental, the third point I make is that when we come to the limitation of constitutional rights, indeed, even when we come to the basic principle of rationality, there has to be a proper basis put up by the respondents. And a proper basis means a proper justification, not with great respect xenophobic tropes, because there are parts of the affidavit, particularly of the LPC, which with great respect amount to little more than xenophobic tropes. And when the LPC says to this court in its heads now that we do not espouse xenophobia, well, that is welcome. But the question is, what does one make of those statements in the affidavit about those xenophobic tropes? And they are neatly set out in our replying affidavit, but they are also neatly set out in the heads of argument for Scalabrini. And we will wait to hear what our learned friends say. But with respect, the problem is this. If this court is to dismiss this challenge, there is a real risk that all it will be doing is fueling those perceptions of xenophobic tropes. But the fourth point, the fourth preliminary point is this. Our colleagues for the LPC are with respect contradictory. They do not oppose the application by Rafoneke. They say they abide that. They say that in the introduction and they say that in the conclusion to their heads. And yet somewhat inexplicably, they do oppose the challenge by my clients, even though, as I've explained, the challenge by my clients is in fact far more, well, not far more, but it is very tightly drawn. And with respect, we don't understand that contradictory stance, and we will wait to hear what our learned friends say. But it does seem that the LPC is equivocal on its stance. With those preliminary remarks, could I now turn to deal with the issues I'd outlined and start by spending 1 minute on direct access? I'm not going to belabor the point unless the court has questions on it, because it seems to us, Justice Madlanga, that this is very much a case on all fours with A party and B, which is that if the court does not drop...
Mr. Butler, only deal with it in reply if any submissions are made against direct access.
Thank you very much.
We've read your submissions in that regard.
Thank you very much, Justice Madlanga. Could I then turn to deal with the category of people affected? And it's important, I've already begun to explain who we're talking about. We're talking about people who, in many cases, have been in this country for many years. They've been here lawfully and they have a right to work. But I want to, if I may, take the court to some of the jurisprudence of this court, which is in fact relied on by our learned friends, and which we say is helpful for us. Could I ask the court to go to Justice Ngobo's concurring judgment in Causa, because our learned friends rely quite heavily on paragraph 59 of Justice Ngobo's judgment. And could I read what Justice Ngobo says and then explain how we fit in? What he says is, it may be reasonable to, so that was a social grant case, of course, as the court knows. It may be reasonable to exclude from the legislative scheme workers who are citizens of other countries, visitors and illegal residents, who only have a tenuous link to this country. The position of permanent residents is, however, quite different to that of temporary or illegal residents. They reside legally in this country and may have done so for a considerable length of time. Like citizens, they've made South Africa their home. While citizens may leave the country indefinitely without forfeiting their citizenship, permanent residents are compelled to return to the country, except in certain circumstances, every 3 years. While they do not have rights tied to citizenship, such as political rights and the right to a passport, they are, for all other purposes mentioned above, in much the same position as citizens. Once admitted as permanent residents, they can enter and leave the country. Their homes, and in most cases their families too, are in South Africa. Some will have children born in South Africa. They have the right to work in South Africa and even owe a duty of allegiance to the state. For these reasons, I exclude temporary residents, and it would have been inappropriate for the High Court to have done so. Now, with respect, my clients and the people who fall into their category are not remotely akin to the temporary residents that Justice Ngobo is saying could have been excluded in causa. They are akin in all but one respect to the permanent residents who Justice Ngobo is saying must be included to satisfy the Constitution. If I work through these very briefly, they reside legally in the country. They've done so for a considerable period of time. They've made South Africa their home. They may leave the country without forfeiting their status. They're not compelled to return to the country. They are, for all intents and purposes, practically speaking, in the same position as citizens. Their homes and their families are in South Africa. They have children born in South Africa. They have the right to work in South Africa. All of those factors, which Justice Ngobo said were enough to say the state must respect their rights as though they were citizens in this case, apply equally. The only one which doesn't is they owe a duty of allegiance to the state, and that was because you have to take a pledge of allegiance is what you do in America, but you have to take the oath committing to South Africa. But of course, we know that there's an easy way of remedying that, which is that you can take an oath to the Constitution when you're admitted, and our understanding is that that continues to be the case under legal practitioners. So the point
at that point, sorry to stop your mid-sentence, Mr. Padlender. Colleagues may now put questions to you. Please continue.
Thank you. So the point I make is that while our learned friends call in aid this paragraph to say, look at this class of temporary residents and they should be excluded, to call my clients temporary residents is not accurate. They are not temporary residents in that sense. They are not temporary resident like the Los Angeles lawyer who comes out to Cape Town to enjoy the sunshine and decides he'd like to practice. That's a sort of temporary resident. We're talking about people who've made South Africa their home. They are not permanent residents only in the sense that they have not yet acquired permanent residence status. That is who we are talking about. And that is a very important point in understanding who we're talking about.
Mr. Butlander, the distinction you seem to draw is to some extent located on the factual circumstances that relate to your client. And you reminded us that this is about objective validity.
Yes.
But if the relief you seek is to be granted, then ultimately it wouldn't really matter if someone subjectively felt a longer term connection to the country. If the relief you sought was granted, it would apply to everybody who, on your formulation, has the right to work and stay, albeit that right might be limited in time. Yeah. Correct. So the comparison, is there a basis then for the comparison to suggest that they are akin to permanent residents in all respects, except possibly in terms of their legal status?
I don't, Justice Colopin, I don't wish to say they're identical, because I accept, of course, that a right to work might be a limited duration. Although, of course, when it's a spousal visa, then it's a different story. But let me be clear, when we considered it overnight in preparing, it struck us that the other way of formulating the relief, perhaps more accurately, might be to do what 2/3 of SADC countries appear to do, which is to say that the words ordinarily resident should be read in. So it's people who are ordinarily resident in South Africa and have the right to live and work. That is implicit in our arguments and indeed in the facts. And that would certainly be a way of avoiding a difficulty of a person who's just here very briefly and has no proper connection to it. So Justice Colopin, I'm so sorry.
Yeah. Sorry, just on that, and can you assist with regard to how the concept of ordinarily resident has been formulated? That would be a factual inquiry having regard to the duration and other circumstances, I imagine, having made a home here, having started a family or whatever.
The beauty of it, it struck me last night, was that it would allow the judge hearing the application for admission to make a decision about whether someone is ordinarily resident. And it would allow the LPC and the bars and the attorneys firms, the attorneys associations to express a view on it. So if I apply and I'm a citizen of the US and I only spend 2 months a year in South Africa, but I somehow have a right to live and work here, the court may well say, you know, we actually want to confine this to people who are making this their home, and therefore you are not ordinarily resident and we're not satisfied. But if you take the example of my clients, and I accept, of course, it must be assessed objectively, but if you take the example of my clients who have been here for over 10 years, their children are here, their wives are here, everything is here, they would certainly be ordinarily resident. So I think ordinary residents, and as I say, it's the approach of, there's been some backwards and forwards in the papers, but on my understanding, there are 16 countries in SADC. We are the 16th. Of the 15 countries, 10 of them adopt a standard of ordinary residence. And of course, it's not a bean counting exercise. I'm just trying to say that would be a basis to do it. But could I return, Justice Colopin, for a moment, if I may, then, on that point to the Larbi Odam case? Because again, in Larbi Odam, there is a very helpful analysis of this point. And in Larbi Odam, it begins, and I would commend it to the court, paragraphs 19 through to 31. 19, Justice Mokgoro explaining the discrimination in that case between citizens on the one hand and permanent residents on the other, and that, of course, was an employment case. And paragraph 24, Justice Mokgoro saying a distinction should be drawn between the impact of the regulations on permanent residents and their impact on temporary residents. The regulations clearly constitute unfair discrimination as regards permanent residents. They've been selected for residence by the Immigration Selection Board. Permanent residents are generally entitled to citizenship in due course and can be said to have made a conscious commitment to South Africa. They're entitled to compete with South Africans on the employment market. As emphasized, it makes little sense to permit people to stay permanently in a country, but then exclude them from a job they are qualified to perform. And again, when you go through and understand the factors she takes into account, it's very much along the same lines. And again, my clients and those in their class are not temporary residents in that sphere, in that sense. Could I then
Mr. Butler, can you please assist me here? We are dealing with confirmation proceedings here.
Yes.
Now, I want to follow up on the debate you had with my brother, Colopin. You are saying that we could follow a nuanced approach regarding your clients. Now, what I would wish you to assist me with is how we would then the order that you envisage we could make in the circumstances, bearing in mind that we are dealing with confirmation proceedings, how we would frame the order pertaining to your clients.
Thank you very much for the question, Justice Chikwi. I've been practicing and I'm afraid I'm struggling, but thank you very much for the question. The answer is twofold. Firstly, of course, on confirmation proceedings, this court always has the ability to vary the order that is granted by the High Court and the remedy that is granted. So a High Court may make a declaration of invalidity in bold terms or with a particular reading in, and this court is always at liberty and indeed duty-bound to grant a narrower or different reading in if it deems appropriate. So the court is at large. But the court is at large for a second reason, and that is because we have also brought an application for direct access. And the direct access application seeks to have this court here as a court of first instance for the unusual reasons set out in our papers, the application which had been launched in the High Court. Now, if I could ask the court to go to our notice of motion in the High Court, I hope that that is the annexure to our founding affidavit in this court, and then the pagination starts again. But the court will see in our notice of motion in the High Court, we dealt with the order that was sought, and prayer 3 said, directing that, well, it's of course a declaration and it's a suspension, and directing that during the period of suspension, section 24(2)b shall be read as though it provides as follows, is a...
You refer me to the age, sorry, Mr. Badlinder. Please assist me.
Page 2 of the High Court record, which is attached to our founding, I beg your pardon, let me take you to somewhere much easier. I'm making life much too complicated. Could I take you to page 3 in the Concord notice of motion? Because we've repeated it there. That was a very long way
Thank you.
around. I do apologize.
Thank you.
It's
Thank
it's page 3 of the notice of motion, and you will see there the reading in that we seek. We seek that 24.2b would now read, you can only be admitted if you're a South African citizen, or you've got permanent residence, or you are lawfully entitled to live and work in South Africa. Now, I've already accepted in answer to Justice Collipin that there would be no difficulty in that third one being reframed to say, is a person ordinarily resident in South Africa and who is lawfully entitled to live and work in South Africa. Now, if you were to adopt that reading in, you would cater for my clients and you would cater for persons in their position, but you would avoid opening the floodgates to every person who happens to have done an LLB or happens to have some other claim. And I would respectfully submit that that is certainly a course open to the court, both as a matter of confirmation proceedings and remedial precision in Rafoneke, and open to the court in these proceedings as a matter of direct access.
Thank you, Justice Madlanga.
Justice Madlanga.
Oh, sorry, continue.
No.
Oh, my brother, Justice Mlambo, please do.
Oh, should I continue? Thank you. Advocate Badlender, I just need to explore with you this issue of the right. You say your clients have the right to work.
Yes.
In South Africa, and it's an uncircumscribed right. Am I correct?
Well, they have an uncircumscribed right under the Immigration Act to work. That's correct.
Right. Now, what stands in their way being admitted as legal practitioners is because they are not citizens, which is obvious.
Yes.
And they are not permanent residents.
Yes.
So they are not permanent residents. You accept that, even though you say all of them have been here for longer than 10 years.
I accept they don't have the status of permanent residents, Justice Mlambo.
You are inviting us to ignore that legal status, or yes, I think for want of a better terminology, you want us to pay no heed to that legal status that they are permanent residents or not, because they've been here. Hence, you say we should adopt the ordinarily resident connotation. Am I correct?
Justice Mlambo, with respect, I wouldn't put it quite that way. We are not asking the court to ignore their status. We are asking the court to say that the distinction between their status as persons who are ordinarily resident with a right to live and work here, on the one hand, and persons who are permanently resident on the other, is a distinction that cannot be constitutionally justifiable. In other words, we accept that under the Immigration Act, my clients do not have a status of permanent residence, and we accept that it's legitimate for the legislature to, under the Immigration Act, say there are some people who are permanently resident and there are some people who are ordinarily resident. But what we say is that just as in Larbi Odam, the distinction that is drawn for purposes of entering the profession between those two categories is constitutionally unjustifiable and should be struck down.
Okay. I know you said you're still going to come to section 22, because I think that's where I want to go to, because I think both Labi Adam, as well as the Union of Refugee Women and Wachenuka, confirmed that a sovereign nation can restrict the access to particular professions and trades to citizens. We can extend it to permanent residents as well, isn't it?
Yes.
Now, you want to add a third category, ordinary residents.
Yes.
Am I correct?
Yes, or ordinarily resident with a right to live and work here.
I see. Okay, no problem. Thank you very much, Justice Madlanga.
Could I turn to that immediately, Justice Mlambo, because that was the very next point on my address, and I must come to it. Could I deal for a moment with the history of Section 22 and its purpose and what we say it is important, why it says what it says? The Section 22, this court has made clear, was included to deal with the history in this country of job reservation, where certain jobs were reserved for certain races, and that horrific history is sketched by this court in affordable medicine. And that is the reason that our constitution, somewhat unusually, has a right of this kind. But the question is a different one as to, but the question of why it is limited to citizens is a somewhat different one. It seems to us that the reason of why it is limited to citizens is for the reason that was given in Wachanuka and which was embraced by this court in Union of Refugee Women, which says, sovereign nations have the right to determine who can work within their borders. That is an elementary principle of international law, and it's been the case for many years. And the fear, no doubt, was that if Section 22 conferred its rights on everyone, not merely on citizens, then it would found an argument, but I am being precluded from pursuing my profession here as a lawyer, as a plumber, as a pilot, as a waiter, because I have a right to work and I am unable to do so because you will not give me the right to work. So it seems to us, with respect, that the decision to put the word citizen in there was primarily a need, as was expressed in Wachanuka and embraced by this court in Union of Refugee Women, to say sovereign nations have the right to decide who comes to live and work here, and the Constitution doesn't alter that. But that is a separate question, with respect, from the question of when you give people the right to work here, under what circumstances can you say you may work, but you may only work in certain professions? Now, again, let me take a specific example. We know that under the Immigration Act, there are scarce skills permits. So if you want a work permit in order to be a nuclear physicist, to take a random example, you might get that under a scarce skills permit. But if you want a work permit to be a plumber, you will not, because there is no shortage of plumbers, although if you ever try and find one on a Saturday, you might have a different view on that. But the real point is that the country is entitled to say, we will give some work permits in that regard. But here we are dealing with something else. Here we are dealing with a situation where the government gives a class of people the right to work and live here. The government also says, via the Legal Practice Act, we are not going to say it's only for citizens. We're going to extend it to permanent residents, people without citizenship, to become legal practitioners. And then the question arises, what is the legitimate basis for distinguishing between permanent residents on the one hand and ordinary residents who have the right to live and work on the other? Now, we accept, as we must, as this court held in Union of Refugee Women. I've seen the heads from Scalabrini who urge a reconsideration of Union of Refugee Women, and I, with respect, submit there's much to be said for it, but let me leave that aside. We accept that on Union of Refugee Women, the distinction that Section 22 draws is a permissible one, is a factor in the inquiry into equality and to dignity. But it is not determinative, because this court in Union of Refugee Women did not say, because of Section 22, there can be no basis for a challenge of this kind, and that is the end. Instead, what it did is it engaged in the classic equality analysis. It asked, what is the purpose of the limitation? It asked, what are the safety valves? And so what happened in Union of Refugee Women is the majority emphasized two things. It emphasized, firstly, and I would refer the court to paragraph 48, it emphasized, firstly, that the door to the private security industry is not completely closed to the applicants. They may enter the single excluded industry if they successfully invoke Section 23(6) of the Security Act. In fact, Section 23(6) renders the provisions of 23(1)A flexible, and if properly applied, will save it from the overbreadth criticism. So this court expressly held that the exemption provision under Section 23(6) of the Security Act was a safety valve which avoided the problem of overbreadth. So it was fine to exclude all non-permanent residents, non-citizens, because the people in the applicant's case could apply to the regulator to be exempt from that requirement. And that loomed fundamentally in this court's judgment. In the present case, there is no discretion. Even if a judge of the High Court were persuaded that a person had lived here for 20 years and was a fine, upstanding citizen and had nowhere else to go, but for some reason couldn't get permanent residence, that judge would have no discretion. And that absence of discretion is fundamental. But the second point—
Mr. Budlander, I'm sorry to interrupt, but can I ask you the same question I put to Mr. Mazibuko?
Yes.
Do you accept that a non-citizen has no right to occupational choice as an incident both of international law and certainly as appears to be an incident of Section 22 of the Constitution?
I accept that a non-citizen has no right to assert occupational choice under Section 22. Yes, indeed.
Well, you've suggested that the difference between a permanent resident and a citizen is really just a question of the oath that you take of allegiance to the country. But there are obligations of citizenship, including, for example, in times of war, that you can be mobilized, and many, many things that are incidents of citizens' obligations to the state that are not borne by permanent residents. And so there is a much more nuanced and complicated relationship between the way in which the state will afford certain privileges to citizens that it doesn't afford to permanent residents, just as the state expects obligations of citizens it doesn't expect of permanent residents. So a question that I have for you is, assuming this legislation had confined admission simply to citizens,
yes,
the logic of your argument seems to suggest that would have been constitutionally permissible. But because it extends it to permanent residents and your clients are, for all practical purposes, like permanent residents, therefore there's a constitutional breach. That seems an argument by extension that doesn't grasp the principle of why a state can restrict opportunities for certain kinds of persons who are not citizens.
Justice Unterhalter, thank you. I do understand the question. With respect, it seems to me the other way around. Assuming that a state is entitled to limit the occupation of a profession to citizens, which I accept is what Section 22 seems to imply, then I can understand an argument that the state could say, we only want citizens as lawyers. The state would still have to explain some or other basis for drawing the distinction, perhaps on the basis that you've done. Maybe legal practitioners are officers of the country, officers of the court, and we only want people who've taken the oath, or whatever, but the sorts of considerations. But of course, and that may well be held to be a rational basis for the distinction, buttressed by Section 22, and therefore no unfair discrimination. I absolutely accept that at the level of principle. But when the state doesn't do that, when the state jettisons that citizen, non-citizen divide and says, actually, we recognize that it is appropriate and beneficial to extend the right to be admitted, or the ability to be admitted, not just to citizens, but to permanent residents. And in doing so creates a different divide between permanent residents and ordinary residents with the right to work, then the state must justify those distinctions. It's similar, if I may say, at the risk of drawing an odd analogy, it's similar to the initial cases on sexual orientation, where the court would say, we are, the bigger bottom, where the legislature would say, we are going to confer benefits on judges' spouses. Now, there was no obligation on Parliament to do it, but once they conferred it on judges' spouses, then they also had to confer it on similarly situated people, i.e. same-sex life partners. So when the state creates an entitlement, and in doing so produces two groups, one who qualifies and one who does not, the state must justify that on a rational and non-unfair discrimination basis.
So just to be clear, your argument is, if the state had pursued a more restrictive approach, then that would have been constitutionally permissible. But because it's applied a less restrictive approach, it's bound to extend the admission to those in like situations. That's the heart of your argument.
That is, with respect, exactly the point. The state must extend it to those in like situations, or must produce a compelling state purpose which justifies the distinction it now draws. And again, if I may use a silly example, suppose that the state had said, we will allow all citizens to be admitted as legal practitioners, and we would allow male permanent residents to be admitted as lawyers, but not women. Well, we would all accept that that is an irrational distinction, even though the women permanent residents don't benefit under Section 22. And the reason is the one you give to me, Justice Unterhalter, in the way you've summarized my proposition. You must extend it to the like category unless you've got a basis for distinguishing between people within that like category. And my submission is that that hasn't been done.
Well, isn't the difference, as some of the cases that you've cited illustrate, that permanent residents have a set of entitlements to be in and out of the country and a certain fixity and continuity of place here that is the difference between them and some of the factual circumstances? You can point to the factual circumstances of your clients, but as a legal status, if they're not permanent residents, they don't, as a matter of status, have the same fixity of connection. Let me put it that way.
Well, with respect, we disagree with that proposition, because they do have the same fixity of connection for as long as they have the right to live and work here. And that's the difficulty I have with the proposition that was put by one of the judges to my learned friend, which said, isn't the LPC or the minister saying people will get admitted and then they'll get into trouble and they'll leave the country and leave their clients in the lurch? Well, of course, a citizen can do that too. If I run into terrible trouble, I can leave the country tomorrow and leave my clients in the lurch. So can a permanent resident. So I'm not saying, let me say, I accept that there is a difference in legal status, because on the one hand, permanent residents have a right to be here permanently, whereas my clients have a right to live and work here for a less permanent period. But we are talking here about permanence in a manner of years. And we are talking here about a class of people who are unquestionably, I can't remember your word, Justice Untold, I think it was the level of fixity,
Fixity of connection.
So they unquestionably have the same sort of fixity of connection. And of course, let me say again, that if the court is concerned that this will be an opening to the person who wants to live in Australia and practice in South Africa via Skype or Zoom, then of course, ordinarily resident would solve that. And the courts will develop, just as they have with fit and proper, the appropriate tests to say, well, you've got to spend more time here, you've got to do this, you've got to do that. And it would allow it to be dealt with in that way.
Yes, thank you, Justice Madlanga.
Justice Madlanga, I'm not sure whether Justice Mlambo was done.
Yes.
Thank you.
I'm done. Thank you, my sister.
Thank you, Justice Madlanga. Mr. Butlander, Section 26 of the Immigration Act provides a permanent resident permit may be granted to a foreigner. A says who has been the holder of a work visa for 5 years and has received an offer of employment. And B deals with the spousal visa, where a person has been in a relationship with a permanent resident or citizen for 5 years. What I'm hearing from you is that your clients in particular, when they applied, they've been in South Africa for more than 10 years, and they have the right to work here.
Yes.
I'm wondering why, if they did apply, you say they applied for permanent residency status, but for some reason or another, they were not granted that. Now, what you are asking us to do now, you want us to then add on to Section 24, another provision that will get them in. Is that not a way of circumventing now the immigration laws?
Yes, Justice Mhlantla, may I answer the question in two ways? The first is to deal with the facts, and the second is to explain why it's not a circumvention. On the facts of this case, the first applicant, Mr. Chaganyuka, could not apply under Section 26 because he was here on a ZEP, which is not a work visa under that section. So he did not qualify, and he was therefore unable to apply. The same with the second applicant. He tried, but was unable to. And in fact, the second applicant made several attempts, we say in our heads at 23.3, he made several attempts to secure permanent residence. He got a high court order by consent in which the Department of Home Affairs undertook to grant him, but it still has not been done. The third applicant was initially here on the basis of refugee status, later on the basis of marital status, and is now on a spousal permit, so again hasn't ticked the box. So what I'm demonstrating is that there are people, and let me say, in fairness, mainly vulnerable people, acutely vulnerable people, who will be here for years, lawfully, who will make this their home, but will not be able to rapidly apply to permanent residence. The people who are likely to be able to apply for permanent residence are the people who get the 5-year work visa from Anglo-American or Standard Bank or Investec, They will be the ones with the resources and the formal permits that allows it. The people who are here are vulnerable. But let me deal with your second question, Justice Mhlantla. Let's assume that this court granted the order that we seek and said that that you can be admitted on the basis of your ordinarily resident. And let's assume that the first applicant now applies tomorrow off the back of this court's order and is granted status as a legal practitioner. That will not confer on that person, on that applicant, a right to permanent residence, anything more than he has at the moment. Because the right to be a legal practitioner is not an offer of work under Section 26, and you will not be changing his or her ability in any case to obtain permanent residence. So it's not a circumvention of 26. What it is it's a way of ameliorating the harsh and unconstitutional effects of drawing the line where Parliament drew it. And so my respectful submission is not, and let me be clear, if the first applicant could have obtained a job as a legal advisor to the Department of Home Affairs, then or the third applicant, the spousal visa, could have obtained the job, they might well have been able to qualify for permanent residence. But it is important to keep permanent residence separate from admission. Granting admission does not confer permanent residence. You're not drawing a line through Section 26. You're not undermining the immigration scheme, because the only people who seek it, who would benefit from this order, are the people with the right to work. And let me say also, and be clear on it, the mere fact that the first three applicants might be admitted as attorneys or advocates would not entitle them to remain in South Africa forever and convert to permanent residence. They would still only have the limited working rights that they have under the ZEP or the spousal permit, etc. So in our respect, you can't conflate them.
And at that point, the 40 minutes is up, Mr. Padlender. How much more time do you want?
I need, if I may, to say one more word on Union of Refugee Women, and then I need to say one word on dignity. So could I beg for 5?
5, that's in order. Thank you very much.
Thank you very much, Justice Madlanga. Justice Madlanga, I wanted to say one more word on Union of Refugee Women, because I've already spoken about the discretion and the safety valve. And in our respectful submission, that discretion is the absence of discretion here is fatal to the constitutionality for the reasons that I've given. It might well have been different if there had been a discretion vested in the court. But the second point I wish to make on Union of Refugee Women is to refer this court for paragraph 60 to 61, because what this court appeared to hold is that there was something special in the security service industry which justified the discrimination in that case. Because at paragraph 60, in dealing with the Andrews case, the Canadian Andrews case, the court said, the qualifications or requirements for the activities of a security service provider and of a lawyer are different. Mr. Andrews probably needed to spend 5 years qualifying himself for the practice of law. He satisfied requirements for the admission of a lawyer. And carried on, it would seem that the private security has its own special requirements for qualification, trustworthiness, devotion to the community, et cetera, and there was a need for background checks and so on. So the court specifically said there was something particular to the security industry which justified a default position of no non-citizens and no non-permanent residents, coupled with the safety valve of Section 23(6). Here, there is no show, in my respectful submission, of anything peculiar to the practice of law which justifies the discriminatory approach. And of course, there's no safety valve. So we would commend those paragraphs. And very lastly, we would submit with respect that the question of dignity does loom large here, because it is one thing to say to people, you can't live and work here for all the reasons set out, Wachanuka, Union of Refugee Women, international law. It is another thing to say to people, you can live and work here. You can get an LLB. You can go through vocational training. But when it comes to being admitted as an advocate or an attorney, you may not do so. What that says with respect is somehow that you are not worthy of that status. And there is no explanation on these papers as to why that would be appropriate, except for the very xenophobic tropes which undermine the right to human dignity that we're so concerned about. So to say to someone, yes, you've passed your LLB at Wits, yes, you've done pupillage with Tererai Mafukidze, yes, you can qualify, you are fit and proper, and yet we will not let you be an officer of our court, even though you have the right to work as the legal advisor to the Department of Home Affairs. that is fundamentally impugning of one's dignity in the absence of a cogent justification. And there is none apart from the xenophobic tropes. And those with respect aggravate the breach of dignity. They don't save it. They don't justify it. They make it worse. And so we submit that in this case, there is indeed a breach of both equality and dignity.
Mr. Butler, just one short question from me. You've invited us to embrace a sort of ordinarily resident category. If we should do so, is there not a risk? And ordinarily resident is used in many other contexts. It might be used for jurisdiction. It might be used in other contexts. Is there not a risk that the unintended consequence would be that one would, from a status perspective, develop a new category outside, as it were, the thinking of the legislature that says that, well, you have citizens, you have permanent residents, you have temporary residents, and then you have a category called ordinarily resident, which could have all kinds of unintended consequences that even now we can't contemplate, as a category of persons who are entitled to particular status or particular set of entitlements. Is there not such a risk?
My submission, Justice Colopin, my submission is no, there is no risk of that sort. And let me say why. The first is, if this court is anxious about that, then of course the court could quite simply limit it to the original reading in, which is people who have a right to live and work in South Africa. And that doesn't create a new status of any kind. And the court would, I was raising it as an alternative to assuage the court's concerns, but we have no difficulty. Either would be adequate and either would remedy the constitutional difficulty. But the second is that you would be conferring no rights on anybody beyond the right to say, where people are in an equivalent position to permanent residents, they have the right to be treated the same, absent a compelling justification. And these facts are decided on these papers. And it might well be that in the next case, when it comes to nurses or when it comes to social benefits or it comes to something else, the state says for X, Y, and Z reason. Let me give you an example. Suppose the state adopted a stance which said we are not going to extend social grants to people who are not ordinarily resident, who are ordinarily resident, but not permanently resident, because the whole basis upon which we give them ordinary residence is that they must have the right to support themselves. Now, I don't know whether that's a good argument or a bad argument, but it would certainly be a completely different justification than the non-existent justification in this case. And so you are not creating a guarantee that ordinary residence is always akin to permanent residence. You are simply saying, for this purpose, admission as an advocate or admission as an attorney, there is no proper basis drawn for the distinction. And that's all the court would be deciding.
Thank you, Justice Madlanga.
Thank you. Are those your submissions, Mr. Butlander?
They are indeed. Thank you for the indulgence, Justice Madlanga.
Thank you very much. We will take the tea break and resume at 11:38. Court adjourned.
Court will adjourn until 11:30. Please note that, Court will adjourn until 11:30. Please note that
38. 38.
All right. Please note that court will adjourn until 11:38. During adjournment, you are welcome to switch off your camera and mute your microphone, and then rejoin with video and sound when the hearing commences at 11:38. Should you exit, you may use the same link to rejoin the hearing.
if everybody is here, Ms. Chitengu, we may start.
Justices, all counsel are online.
And are all my colleagues here as well? Yes, all right. Yes, Ms. Richards?
As the court pleases, justices, I want to start off by stating that I fully associate myself with the arguments advanced on behalf of the applicants, specifically the appellants, both the appellants and the applicants, and specifically those made by Advocate Budlander on behalf of the further applicants. Justices, I will consequently not belabor this court with a repeat thereof, but will focus on the additional submissions to be made on behalf of the intervening party, rooted in her unique circumstances and on behalf of herself, but also to the benefit of those in a similar position. Justices, the intervening party is a Zimbabwean national who is lawfully entitled to live and work in South Africa. She passed the legal practitioner's admission examination and complied with all of the requirements to be admitted as a practicing legal practitioner, save for the citizenship and or permanent resident requirement in Section 24(2)(b) of the Legal Practice Act. In addition hereto, she has also passed the conveyancer and notary's admission examinations. It must be reiterated, and it is of grave importance to state that the intervening party is in absolutely no way advocating for a provision to circumvent the immigration laws and regulations of this country. And practicing as an attorney and conveyancer will always be subject to the individual's right to live and work in South Africa. The applicant's intended admission and enrollment as a notary and conveyancer, in addition, or rather in conjunction with her admission as a practicing legal practitioner, forms the gravamen of the unique submissions that will be made in addition to what my colleagues have stated. In terms of the definitions contained in the Legal Practice Act, a conveyancer is a practicing attorney who is admitted and enrolled to practice as a conveyancer in terms of the Act. And furthermore, a notary is a practicing attorney who is admitted and enrolled to practice as a notary in terms of the Act. Section 24(2)(b) of the Legal Practice Act states that the High Court must admit into practice and authorize to be enrolled as a legal practitioner, conveyancer, or notary any person whom, upon application, satisfied the court that he or she is inter alia, duly qualified, fit and proper, and a South African citizen or permanent resident. A conveyancer and notary is considered to be a practicing attorney by the Act itself. And as such, being admitted as a practicing legal practitioner is essentially serves as a gatekeeper to being admitted as a notary and conveyancer. There's an unjustified blanket exclusion on those who are not citizens or permanent residents, but who are lawfully entitled to live and work in South Africa from also practicing as conveyancer and notaries. And the respondents have failed to appreciate the extended impact of the impugned provision. Consequently, if one considers the unique circumstances of the intervening party, any argument on the availability of alternative avenues for those who can now be admitted as non-practicing legal practitioners as justification for the limitation created by the impugned provision does not carry any weight in respect of an admission as a notary or conveyancer. The sole purpose of writing notary and conveyancing admission examinations is to practice as such. Being admitted as a non-practicing legal practitioner will not suffice, as practicing as a conveyancer or notary is akin to practicing as a practicing legal practitioner. The High Court judgment in the Rafoneke matter, in as much as it will allow the intervening parties admission as a non-practicing legal practitioner, will be of no assistance to her and others who are in a similar position. consideration of the extended impact of Section 24(2)b of the Legal Practice Act is a vital consideration upon determination of the constitutional validity of the impugn provision. The submission made by myself and my colleagues is that the impugn provision unjustifiably limits the right to human dignity and equality in terms of Section 9 and 10 of the Constitution.
The 5 minutes is up, Ms. Richards. My colleagues may put questions to you now. Please continue.
So the impugn provision unjustifiably infringes the right to equality. It does not bear a rational connection to a legitimate government purpose, as it regulates in an arbitrary manner and manifests naked preference. This is something that my colleagues have stated.
Ms. Richards, Ms. Richards, excuse me. This concept about non-practicing conveyancer and non-practicing notary, where does it find its place in the Legal Practice Act? Do we have such a thing like that?
There is no such thing. That is the very point of our argument, Justice Matopo. The very point of our argument is that you cannot practice as a conveyancer or notary in absence of being admitted and enrolled as a practicing attorney. And in that sense, the impugn provision goes further than only barring people from practicing as attorneys. It also goes so far as to limit people's rights to practice as notaries and conveyancer. And that's the extended impact which we wish to bring to this court's attention for this court to consider, because no evidence has been provided by the respondents in this regard, proving what the reasons are for barring people from becoming notaries and conveyancers in this country, from barring people.
Excuse me, does it mean that she suffers what I would call is a double whammy? She can't be an attorney, she can't be a notary, or triple whammy notary. And what becomes of her thereafter?
Yes,
Nothing.
what becomes, and the thing is, what we're stating, Justice Matopo, is that there might be other reasons to go and write the admission examination to be qualified as a legal practitioner. You might want to qualify as a legal practitioner to go and work for a big company, and they might require your admission. And in that sense, there might be other opportunities available. But the sole purpose of writing the notaries and conveyancing exams is to practice as a notary and conveyancer. And in that sense, the judgments in Rafoneke, enabling the intervening party to practice as a non-practicing legal practitioner does not assist her and those in a similar position.
Are her circumstances more closer, just remind me, more closer to Rafoneke or Chakanyuka?
So it's closer to the applicants, not the appellants, in the sense of she's also in South Africa on a Zimbabwean exemption permit.
No, just mention it. I understand them more clearly by their names. Is it Rafoneke or Chakanyuka?
Chakanyuka, yes.
Chakanyuka, okay.
Yes, so we're making the exact same argument.
So if it's okay, thanks. Okay.
Thank you very much.
Can't an argument be made, though, Ms. Richards, that the would-be notary public and the would-be conveyors have themselves to blame? Because if the law says you cannot be admitted, so they as lawyers should know that they cannot be admitted and therefore should not even do a conveyancing course or the notary public course. Don't they have themselves to blame?
With respect, Justice Madlanga, I think sometimes we do things in hope of the wrongs being righted by this very court. Just because an act is allegedly unconstitutional should not deprive people of challenging that unconstitutionality. And her intention to become a notary and conveyancer might have always been with its intention to also approach this court to ensure that others in a similar position can also fulfill what they want in life, and for their dignity not to be impaired by them being deprived of making what they are passionate about the very basis of their living, as well as stated in various pieces of case law by this court, that when one is deprived of that, it impairs your human dignity. And she's unable to practice, and there's no rational reason. And there's also no evidence in support of the alleged floodgates argument provided by the respondent, specific evidence and specific factual evidence showing that there's no space for conveyances in this country. So the question is, why is everyone else who is entitled to live and work in South Africa, they can pursue the careers that they want to? But in the intervening party's instance, she's unable to practice as a notary and conveyancer just because generally there's apparently a job shortage, or she's less temporary here, which is something that I will address to this court. Thank you very much. May I continue with my argument?
Yes, yes, please.
So the rationales that have been provided include the protectionist rationale. I've given them names just under general labels, but the protectionist rationale reserves the right of access to the legal profession and the attendant economic benefits to citizens and permanent residents. That's a protectionist, that has a protectionist rationale behind it. And the administration of justice rationale is the rationale that relates to promote the administration of justice and to protect the public from unqualified or negligent practitioners, as they state. Now, what we're stating is the administration of justice rationale is irrational upon consideration of the intervening party's unique circumstances, as acquiring permanent residence or citizenship does not affect how justice is administrated. The regulatory control for admission as a notary and a conveyancer remains the same. Foreign nationals will have to comply with the same requirements in pursuit of practicing as a notary and conveyancer, including being fit and proper. And labeling individuals who are not holders of a certain status as likely problematic or likely negligent is unfounded and offensive. The protectionist rationale is irrational also upon consideration of the fifth intervening party's unique, the intervening party, she was initially the fifth one, the intervening party's unique circumstances, as immigration policy is regulated by immigration laws and legislation. Those who seek to be admitted as conveyancers and notaries are allowed to appear in certain forums, including magistrates' courts, up to the point of having complied with all of the further requirements for admission, but not thereafter, which is completely unfathomable. They are allowed to act as officers of this court until they pass an examination, which in my opinion, and with all respect, does not make sense. As
Ms. Richards, just on that point, which was made in the Hertz, I was just thinking that that kind of appearance, or that form of appearance, is not so much as, it's not classified as practicing. It's part of the training and what the respondents call part of they use the word vocation. So the way you're using it, it's as if they are allowed to practice in the country and then suddenly are disallowed from practicing. But the point is, it's part of their training.
I understand your question fully, and I'm glad this question is asked, Justice, because I'm saying that not in context of making the allegation that one is entitled to practice up to a certain point. I'm stating that with specific reference to the rationale that was provided, and that is to protect the public against possibly negligent practitioners. But those very practitioners are allowed to appear in forums whilst they are, or possibly in future negligent practitioners are allowed to practice whilst they are candidate attorneys without any fear. And your question.
Sorry to interrupt you. I know you're trying to make a point, but your time is limited. So I just want to afford you an opportunity to deal with my concerns. When they practice as such, for instance, candidate attorneys serving articles, they are under the supervision of their principals. So that fear of negligence, etc., is not there because it is assumed that they are under the supervision of their principals, and they also are not entitled at that stage to operate trust accounts.
Thank you very much. I think I understand the question better now. My point goes to,
before you respond, your time is up. How much more time do you want?
If I can have 5 more minutes just to answer this question and to make my final submissions, that would be fantastic.
So all told, 5 minutes all told.
Yes, I mean, if there's no further questions, I have a few things.
Of course,
to get
of course.
through.
Okay.
I have 5 to 7 minutes. Then
okay, let's say 7 minutes then. All right.
Fantastic. Thank you so much.
To my sister, Justice Chick.
Justice, in the context of my specific submission, and I do appreciate the fact that candidate attorneys are supervised doing the sustenance of doing the vocational training. But my point goes to the fact that, and you asked the question, and I agree with such question, that they are being trained for something. This begs the question, what are they being trained for? To appear in these forums if they're not allowed to practice in those forums thereafter. And that's what it goes to, is we trust these candidate attorneys enough prior to them being admitted and to train them. But what are we training them for to appear in these forums if they are not allowed to appear in any forum thereafter? But I do appreciate and I agree that there is a overseeing principle that continues throughout being a candidate attorney, throughout the sustenance of being a candidate attorney. So I do appreciate that. I hope I answered the question.
Ms. Richards, sorry, I think my sister is done with you. And I want to follow up on the vocation or the vocational training. But slightly differently. Before they enter into articles or pupillage, they would have submitted certain documents to the regulatory bodies. And those regulatory bodies, i.e. the bar, PABASA, or the Legal Practice Council, would have looked at the documents at that point, would have made an assessment, i.e. whether if you want to embark on a period of articles or pupillage, at the end of the day, there would be that expectation that you would want to be admitted. And they registered these candidates. And as correctly you put it, the training, what was in aid of? I just want to understand whether any blame could be apportioned to them or to the bodies that registered them.
As I stated earlier, Justice Matopo, I don't believe that blame should be placed on candidates with hope to one day practice as legal practitioners. Even if they embark on being candidate attorneys and going through the vocational training with hope. I do, however, believe that some negligence or some of the fault can be apportioned to the regulating bodies because they knowingly register these candidates and allow them to write all of their admission examinations, including notary and conveyancing examinations, that they won't be able to practice as such and that they will continue to oppose any practice. I think that's maybe more important to state that they register them knowing that even should these candidates challenge the Legal Practice Act, they will oppose it. And they will continue to fight for their exclusion. So in that sense, I do think some of the blame can be apportioned to them, but even if some of the blame can be apportioned to the actual candidates themselves who embark on this journey to become legal practitioners, conveyancers, and notaries, I do not believe that that fault is enough to justify the restriction and to not fight for such restriction. Thank you very much, Justice Martin.
Ms. Richards, I know your time is short, but can I just ask you one very quick question? I'm assuming you don't think it's irrational to require that a conveyancer or a notary must be admitted as a practicing attorney.
No, that is not our submission. That is not our submission.
Yes, so
Please
go ahead.
We believe that it is part and parcel of practicing as an attorney, and that's our very submission. That practicing a conveyancer notary is akin to practicing as an attorney.
So if it were defensible to restrict admission of legal practitioners on the grounds of citizenship and permanent residence, then there would be nothing that would be distinctive about the difficulties that your clients have. In other words, if it were permissible to restrict someone to be admitted as a legal practitioner on grounds of citizenship or permanent residence, then you would have to accept that there's nothing special about the case of conveyancers or notaries. Is that correct?
So what we're stating is, and I agree with this point to the extent of it being one in a kind, and if the one is justified, the other one is probably also justified. That we can agree with. But what we're stating is that in terms of standards laid down by this court in matters such as the NICRO case, sufficient evidence has to be provided in dispute or as in support of the justifications provided by the respondents, rather, not just mere policy allegations or policy considerations, but it has to be supported by factual evidence. And what we're stating is that the manner in which we are distinct is that even if this court finds that sufficient factual information has been provided to indicate that the practice as general practice as attorneys is flooded, and consequently there is a valid reason for the impugned provision. What we are stating is that that proof has not been provided in terms of notaries and conveyancers, and that this bar goes further to exclude such candidates as well, and that it cannot be consequential, even though it is part and partial. It should not be considered consequential because there should also be a rational. It should be proven in its entirety by the respondents that the justifications, i.e. the administration of justice rationale and the protectionist rationale, is also applicable to the extended impact of practicing as a legal practitioner. And I can go further, but I mean, that's not part of my submissions to state that an advocate is then also a necessary extension in this regard. And advocates are also being deprived of these very rights. What we're stating is that the respondents have not appreciated the extended impact, even though it's part and partial. They have not appreciated the extended impact of this blanket provision.
Yes, thank you.
I am going to...
Your 7 minutes is up. How much more time do you want? I know, of course, my colleagues engaged you, so how much more time?
Thank you very much for being reasonable. I need 5 more minutes. I need 5 more minutes, and then I will be done.
Please, thank you.
Thank you very much. Thank you. So, as I've stated, another possible means of justification that deserves consideration was rooted in the availability of employment opportunities to citizens and permanent residents post-articles. This was considered in the Rafoneke matter, and in my opinion, this is part and parcel of the protectionist rationale. However, as I stated, no factual evidence has been provided in relation to notaries and conveyancers in this regard and how employment opportunities suffer post-article within this realm. And consequently, the extended impact is grave in this sense. And furthermore, no factual evidence of how the floodgates will open within this context, this specific context, has been provided. Permanent residence and citizenship, and this is an important point I make, does not guarantee permanency. And my colleague has also stated this. As attorneys, notaries, and conveyancers who are permanent residents and citizens are always in a position to relocate elsewhere at any point in time, in the middle of a matter, should they wish. Ironically, they are able to obtain employment as legal practitioners, conveyancers, and notaries in other jurisdictions, and regularly do. If anything, the intervening party has showcased a very clear will of practicing as an attorney, notary, and conveyancer in South Africa, with the intention of doing so for as long as she's lawfully entitled to. This has also been stated in case law, that that sense of permanency is not necessarily linked to your status. There's no proof of the allegation that the intervening party would impose some inherent danger to the legal system if she was allowed to practice as a notary and conveyancer. And also, no proper factual evidence and reasons in support of the purported justifications to the absolute exclusion of legal practitioners, notaries, and conveyancers have been provided to this court. And the standard as laid down in this court by, for instance, the NICRO judgment, as I've stated, has not been met. And I wish to go further and submit that even if this court finds that the evidence in support of the rationales was provided by the respondents, it cannot be stated with regards to the proper justifications not to be admitted to practice as a notary and conveyancer. And there is no provision in the Act that allows for the intervening party. As Justice Unterhalter rightfully stated, there's no provision in the Act allowing for the intervening party to practice as a conveyancer and notary separately and distinctly from practicing as a practicing legal practitioner. The intervening party wrote and passed the conveyancer and notary's admission examinations with the intention to undertake it as a profession and to make it the basis of her life. For the additional reasons provided, it is submitted that the impugned provision does not pass constitutional muster and should accordingly be declared unconstitutional. Thank you very much. Those are my submissions.
Thank you very much, Ms. Richards.
Thank
you. Mr. McConaughey.
Thank you, Justice Madlanga. Thank you, Justices. Justice Madlanga, the Scalabrini Centre agrees with the applicants in the Chakanuka application that Section 24(2)(b) is unconstitutional to the extent that it excludes from legal practice foreign nationals who have an existing right to work in South Africa, but may not be permanent residents. But what we would add to this analysis is that the unconstitutional impact or the assessment of unconstitutionality is fundamentally incomplete without considering the particular effect of this provision on refugees and asylum seekers, who, as this court has repeatedly confirmed, occupy a unique status in our law and are indeed also particularly vulnerable. So it's in that light, Justices, that I propose to address three brief submissions in my 15 minutes. The first is the specific effect of this exclusion on this vulnerable group. The second is why that effect is patently unfairly discriminatory. And the unfair discrimination is compounded by the what Mr. Bundler has called the xenophobic tropes that have emerged in the respondents' affidavits. And finally, I will briefly address the question of the introduction of new evidence. But to preface my submissions there, I emphasize that Scalabrini has confined the new evidence to the 4 affidavits of individual asylum seekers and refugees in support of this application, who describe the experience of being excluded from the legal profession. Scalabrini does not persist in the admission of the further evidence that was before the High Court, although I stress that all of this evidence that was before the High Court in Chakanuka was not disputed by any party. And indeed, there's no factual dispute in respect of the 4 individual asylum seekers and refugees. So, Justices, I would like to then turn to the first topic, the impact of the exclusion on refugees and asylum seekers. As I've already noted, this court, from Union of Refugee Women through Ruta, through Ahmed, and beyond, has repeatedly emphasized the vulnerable status of refugees and asylum seekers. They owe their protection in South Africa both to international law and to the Refugees Act. And they are perhaps unique in this country as being a group of individuals who also owe their protection to the legal profession. Legal professionals, many of whom on this call today, act for refugees and asylum seekers in advancing their asylum claims and in defending their rights throughout their stay in South Africa. But yet, Section 24(2)b tells these asylum seekers and refugees that while they are the law's grateful supplicants, they're its subjects, they cannot be its agents. And indeed, they're robbed of the ability to practice law in their own right. This is despite the fact that refugees and asylum seekers have rights to work in South Africa. In the case of refugees, that's an unqualified right. In the case of asylum seekers, it's subject to conditions which we've set out in the heads of argument, but it is indeed not disputed that the majority of asylum seekers also enjoy rights to work and to study. But yet these refugees and asylum seekers are told that they must wait until they qualify for an application for permanent residence until they can practice. But what that means, justices, in the case of refugees who once they've been recognized and granted asylum, they must wait under the new law a period of 10 years before they can be eligible to make an application for permanent residence. And I stress there it's purely eligibility. It's not guaranteed. And indeed, there is the cases have acknowledged that there are systemic backlogs in the processing of these permanent residence applications. But that statutory 10-year waiting period comes on top of the long period of delay that most asylum seekers face in waiting for asylum decisions. That's again, nothing new. It's been repeatedly acknowledged by the courts, including the SCA, which have emphasized that asylum seekers may often wait up to a decade before their asylum application may be processed. So in effect, it would not be out of the ordinary course for an asylum seeker entering the country who studies an LLB to have to wait a period of up to 20 years before they could enter legal practice by virtue of the particular statutory bar in Section 24(2)b. But we highlight the impact this has had on individuals in the 4 asylum seekers' affidavits, because their experiences we submit have not been adequately reflected in this matter and highlight the barriers to entry. And I focus on one individual in particular because her experience is indicative, and that is Ms. Kelly Matendu, who fled the DRC in 2009. She gained asylum in this country in 2013, and she had been a lawyer in her home country for 5 years before fleeing. In fact, she had her law degree accredited by our South African Qualifications Authority as being equivalent to the LLB in all respects. But yet
at that point, the 5 minutes is up. My colleagues may put questions to you. Please continue, Mr. Makonaki.
Thank you, Justice Madlaga. Just to emphasize one point on Ms. Matendu's experience is that she is now forced to sell curios and crafts in a craft market. She would be denied admission to practice, even if she were to go through the various other hurdles of Article.
Sorry, Mr. Makonaki, the case you make out is that refugees and asylum seekers find themselves in a particularly unique position, and that the barrier for entry is even greater because they would have to wait for 10 years. But is the whole system of asylum not based on the notion of temporary protection? That you're entitled to the protection of South Africa, for example, as long as you remain at risk. And if that risk no longer persists, then you can avail yourself of the protection of your country of origin or any other country, then your status as an asylum seeker or a refugee may lawfully be terminated. Whereas your argument appears to be premised on the notion, and I may be wrong, that refugees and asylum seekers really have de facto some permanent sojourn in the country. And if that was not the case, then is the foundation of your argument not to some extent premised on a notion that refugees and asylum seekers are permanent, whereas in fact the very structure of international law and the South African law is not based on that permanency?
Justice Colpin, I'd answer that at both level of fact and at the level of principle. At the level of fact, we know that the conditions in Africa, and indeed South Africa's own experience of having asylum seekers and refugees fleeing to other countries, that condition is indefinite for many. These circumstances that cause individuals to flee and require asylum are not circumstances that disappear overnight. Indeed, in the 4 individual examples we presented, all individuals have been in this country for more than a decade. But as this court has also emphasized, Justice Colopin, at a matter of law, all asylum seekers and refugees, or at least all asylum seekers, have a legal right to remain in the country pending the final determination of their status. And that, of course, comes through very strongly in the Saidi judgment and in recent judgments. But as a matter of law, we know that is a status which is indefinite. It lasts for many years, not only because of the protracted delays in the system, but also because of various legal rights to challenge and to review these decisions. So de facto, Justice Colopin, we would submit refugee status and asylum is a condition that allows individuals to live and work. And indeed, this country has always premised its refugee protections on an integrationist approach. The asylum seekers are not confined to refugee camps at our border. They are part of our society. They're allowed to live their lives, to study, to work, and make themselves meaningful members of our community. Justice Colopin, if that addresses that question, I'd like to turn briefly to the second topic, which is that of unfair discrimination.
Advocate Makonachi, sorry, Advocate Makonachi. I just want to explore that response further to Justice Colopin's question. Are you suggesting that, as a matter of law, we should accept that when a person presents herself and seeks refugee protection of this country, that presents some form of permanent sojourn in this country?
Just Mlamo, yes, it does in fact convey a degree of permanence. In particular, once refugee status has been confirmed, that status exists until so long as the standing committee decides to withdraw that status. And indeed, as you will see from the permits that are attached to the papers, asylum seekers and refugees, or at least refugees in particular, are given the rights, all rights within the Bill of Rights, including the rights to live and work, without qualification. There's no suggestion that that is confined to a specific period of months or even years.
No, but I think the principle of refugee protection, which Justice Colopin put to you, is that it is temporary in nature, temporary in the sense that until your country of origin circumstances change, then you may have to go back. In fact, you will be requested to go back, like we saw with the Angolan refugees. So I want to understand, how can you suggest to us that there's permanence if anyone is granted the refugee status? Because it's not. And that's the structure of international refugee protection, isn't it?
Just Mlamo, I would submit it's permanent in the same way that permanent residence is permanent, that rights exist until they are withdrawn. And that is indeed the status of refugees, and we would submit it would also be the status of asylum seekers, who have rights to remain until their claims are finally determined.
Okay, I've heard your submission.
So I accept, of course, that, thank you, Justice Mlamo. I accept, of course, that a matter of law, there is a distinction, but in practice, that is a crucial distinction. Justices, if I may make two submissions briefly on unfair discrimination. We submit firstly that this court's assumption in the Union of Refugee Women that refugee status is an analogous ground in its own right, that assumption is indeed correct, and we submit that given the 16 years of case law from this court, acknowledging the particular vulnerability of refugees and asylum seekers, it is now an appropriate time to confirm that assumption as being correct. The second submission we make is on the unfairness of this exclusion for asylum seekers and refugees. And the unfairness we submit operates at three levels. It's at the individual, the group, and also at the level of society. At the level of the individual, the 4 individual affidavits that we have submitted to the court illustrate how exclusion from legal practice can deny individuals the ability to self-actualize by applying their existing legal skills, applying their abilities to their fullest. But at the level of the group, it's not merely a denial of a particular job to particular individuals. We submit that at the level of the group, this is the denial of entry to a vocation that carries with it immense social status, immense social responsibility, and immense social power as well. That the opportunity to present submissions to a court is something which is perhaps the greatest expression of civic agency in this country. But yet, to exclude all asylum seekers and refugees, no matter what their qualifications are, from legal practice, sends the very clear message that regardless of their qualifications. They are second class, their allegiance to the Constitution is in question, they're untrustworthy. And indeed, the court doesn't have to look for implicit messages. Those are in fact the explicit messages that come through strongly in both the Minister of Justice's answering affidavit, but particularly the affidavit deposed to by the chairperson of the Legal Practice Council in the High Court in Chakanuka, where amongst other tropes that were advanced was the suggestion that other individuals who are not permanent residents are not fully committed to South Africa. They're not committed to the Constitution, and indeed that they're not committed to legal practice. So it's in those circumstances, Justices, we submit that this is a case where the justifications advanced are not justifications at all. In fact, what they do is to entrench the unfair discrimination in this case by perpetuating a level of prejudice and stigma which this court has repeatedly warned against. And we highlight in our heads of argument what Justice Sachs emphasized in Union of Refugee Women, that if refugees are treated as intrinsically untrustworthy, with their capacity to perform honestly and reliably being placed presumptively in doubt, then xenophobia is given a boost and constitutional values are undermined. So just to summarize this point on unfair discrimination, the court will search in vain in these papers to find any specific justification advanced for the exclusion of refugees and asylum seekers. None has been advanced because we submit their interests have been entirely overlooked in this process. And that in itself is a further manifestation of the unfairness of the discrimination.
Mr. McConaughey, as a matter of international law, do refugees or asylum seekers have any rights of access to professions or classes of work in the countries in which they seek asylum?
Yes, just on top of the answer is yes, indeed. And it flows from various
direct us to which instruments and what they say.
Yes, just on top of the primary instrument, which is explicit about refugee protection, is the 1951 UN Refugees Convention, which has a triad of articles which confer working rights. There is Article 17, which is confined to wage earning employment, salaries, wages, and the rest. Article 18 is the right to self-employment, which many legal practitioners would fall under. And then finally, there's a curious provision, well, it's curious in its wording, but not curious in its impact, and that is Article 19, which is the right to enter liberal professions, which, as we have pointed out in our heads of argument, has been interpreted by leading international law scholars as applying to the legal profession. And that is a right which we emphasize contains the exhortation to states to give asylums, or give refugees lawfully staying in a country treatment as favorable as possible. And I would underline that, treatment as favorable as possible, as being a particularly important right. Now, just Untalte, I am grateful for the prompt because it's relevant when it comes to distinguishing Union of Refugee Women in this case, that Union of Refugee Women dealt exclusively with Article 17, which is a right to wage earning employment, but did not consider the further articles, Article 18 and Article 19 in that case. And while in our heads we've advanced an argument about why the majority in Union of Refugee Women was wrong in its interpretation of Article 17, we would submit that this court is fully at large to also consider Articles 18 and 19, which are more directly applicable in these circumstances.
Does the implication of this suggest that that refugees and asylum seekers have more favorable treatment under our constitutional regime than, say, persons who come and are temporarily residents in the country?
Yes, just as a matter of law, they do have more favorable treatment. But we would, of course, not go as far as to say that the exclusion of others, such as those in the position of the Chakanuka applicants, the Rafoneke applicants, can be legitimately excluded. But we would say that refugees and asylum seekers are legally entitled to a greater degree of preference and indeed a greater degree of protection.
Thank you.
Just Malanga, I see I've exceeded my time.
Yes. Yeah, you are 2 minutes beyond your time. How much time do you want? I see that it looks like my brother Justice Mlambo wants to put a question to you.
Just a brief one, Justice Madlanga. Advocate Makonachi, when you were asked by my brother Unterhalter about the rights that refugees and asylum seekers have to choose their professions in this country, you referred him to the UN Convention. I know we also have the OAU Convention and we have the Refugees Act in this country that have domesticated both those conventions. But I'm not aware, maybe you can point me, where these articles that you specifically referred to have been domesticated in this country.
Justice Mlambo, we would say explicitly it's domesticated in two places. The one is most explicit in Section 1A of the newly amended Refugees Act, which says that the Act must be interpreted and applied in a manner that's consistent with international instruments, including particularly the 1951 Convention. And then if the court would then read that together with Section 27F of the amended Refugees Act, which is the right of refugees to seek employment unqualified.
Yes.
It's in that context, Justice Mlambo, that we would submit that there's nothing in the Refugees Act that seeks to curtail the international rights, but indeed in the open-ended language that they use, coupled with the exhortation to interpret consistently, that must mean giving refugees at the very least their full range of international law entitlements.
Okay, so I should look at those two sections in particular in the Refugees Act, because I think the question that was asked of you was, in our own domestic environment, where can we find these rights? And you say, I should look at this.
Indeed, Justice Mlambo, those are the key provisions. And of course, in addition to that, I would refer the court to what this court said in Saidi about rights to work being an important component of a life of dignity for an asylum seeker in the country. But I appreciate the prompt, Justice Mlambo.
Thank you very much, Justice Madlanga.
Justice Madlanga, if I may have 30 seconds just to say one final word on the new evidence. Justice Madlanga, we've submitted to the court already that this is a matter that clearly falls under Rule 31. The 4 individual affidavits from the asylum seekers have not been denied on their substance and their facts. We understand that the Minister of Justice initially took a point that evidence about backlogs and delays in the asylum process could not be admitted. But of course, we have abandoned the admission of that new evidence and only to focus on the specific categories of individual evidence, which are not meaningfully disputed. And indeed, we submit to the court that those individual experiences are reflective of the experiences of all asylum seekers and provide vital context and relevant context to the way in which this court ought to decide the matter. Thank you, Justices. Those are our submissions.
Thank you, Mr. McConaughey. Ms. Powen.
Good afternoon, Justices. As the ICJ, we broadly align ourselves with the submissions made by the applicants and go further to say that the impugned provisions also fall foul of international human rights law and standards that are applicable in South Africa. To this end, our submissions will focus on extracting principles that we believe this court ought to consider in the determination of this matter. And we say that this consideration is warranted because the court is enjoined to do so in terms of the Constitution. Justices, I would propose to deal with 2 broad topics. The first being the right to equality and non-discrimination in international law, coupled with the right to work. And the second issue being the legal obligations imposed on South Africa in respect of the right of choice of counsel. Now turning to the right to equality and non-discrimination, justices, a variety of international instruments set out protections related to the right to equality and non-discrimination. We've set these out comprehensively in our heads of argument. I choose to stress that these instruments provide for a right to equality and equal protection of the law. Further, that the committees dealing with these treaties have gone on to pronounce that repeatedly that discrimination on the basis of nationality may fall foul of Articles 26 and 2 of the ICSCR, as well as the ICCPR. We have listed these determinations at footnote 16 of our submissions. In respect of the prohibition against discrimination based on nationality, the general comments particularly General Comment 2 at paragraph 20 makes it clear that the ground of nationality should not bar the access to covenant rights, and that covenant rights apply to everyone, including non-nationals such as refugees, asylum seekers, stateless persons, migrant workers, and victims of international trafficking, regardless of legal status and documentation. Justices, we do not intend to say that all differentiation is prohibited. In fact, the Inter-American Court of Human Rights, the advisory opinion 18 of 2003, which can be found at footnote 25, is instructive in what states should consider. And that is that states may grant different treatment to documented migrants and in respect of undocumented migrants or between migrants and nationals, provided that such differentiated treatment is reasonable, objective, and fair, and does not impair human rights. Consequently, states have an obligation not to introduce discriminatory regulations into their law and to eliminate regulations of a discriminatory nature, to combat these practices, and to establish norms and other measures recognizing and guaranteeing all persons effective equality before the law. And in considering the justification put forward by the state respondents, justices, I draw your attention to the African Commission's communication number 159 of 96. I practiced yesterday how to read the case name, but my French is woefully bad. And so I won't attempt to do so, but direct the court to footnote 17, where we set out the case name in totality. There, the commission was asked to deal with the expulsion of certain West African nationals from Angola. And the commission opinioned in paragraph 16 and 18 that although the commission exceeds that African states in general and the Republic of Angola in particular face many challenges, mainly economic, in the face of such difficulties, states often resort to radical measures aimed at protecting their nationals and their economies from non-nationals. Whatever the circumstances may be, however, such measures should not be taken at the detriment of the enjoyment of human rights. It goes on to say that Article 2 of the Charter, the African Charter that is, stipulates that every individual shall be entitled to the enjoyment of rights and freedoms recognized and guaranteed in the present Charter without discrimination of any kind, particularly on the basis of ethnic group, color, sex, language, religion, political and/or opinion, national and social origin, fortune, birth, or other status. This text therefore obliges state parties to ensure that persons living on their territories, are they nationals or non-nationals, enjoy the rights guaranteed in the Charter. Justice is now turning to the right to work, which I realize is a contentious issue.
Before you do the 5 minutes is up, please continue.
Thank you, Justice Malanga. Now turning to the right to work, justices. South Africa has acknowledged the absence of a designated right to work in the Constitution. However, it has committed itself to the realization of this right by becoming party to a range of international treaties that recognize a legally binding right to work. Although we focus in our submissions, you will see, on the ICSCR and the African Charter, there are many other treaties that do so. We've listed these at footnote 26 of our heads. The ICSCR at Article 6 to 8 explicitly states that the right includes the right of everyone to the opportunity to gain his living by work, which he freely chooses, and requires state parties to the ICSCR to take appropriate steps to safeguard these rights. State parties are therefore required by the ICSCR to allow for all persons to make a decent living for themselves and for their families. It also goes on to guarantee the right to an adequate standard of living at Article 11 and includes a right to continuous improvement of living conditions. Justices, I also draw your attention then to General Comment 18 and 23, which give further meaning to this text. And there, the Commission has found that the right is clearly guaranteed to everyone, and further it obliges the state to put in place immediate measures to deal with it, with the right of access to work and makes it an immediate obligation. My apology. Lastly, just to pinpoint, General Comment 18 in relation to the right to work provides that states are under the obligation to respect the right to work by refraining from denying or limiting equal access to decent work for all persons, especially disadvantaged and marginalized individuals or groups, including prisoners, detainees, members of minorities, and migrant workers. This leads me to whether non-citizens' right to work in South Africa and how we reconcile international law with the South African framework. Justices, the SCA in Wachanuka and Somali Association has recognized that the right to dignity must be interpreted to include protection of the right to work of non-citizens in South Africa. This approach, we submit, is consistent with the right to work of non-citizens under international human rights law. Particular attention is drawn to General Comment 18 again, where the committee stressed that the right to work is essential for realizing human rights and forms an inseparable and inherent part of human dignity. Every individual has a right to be able to work, allowing him or her to live in dignity. Then the question becomes, does the right to work include the right to choose one's profession in the international law regime? And to this end, we place reliance on Article 6 of the ICSCR. And there, the convention states that the right to work is a right to gain his living by work, which he freely chooses or accepts. Justices, we further draw your attention to consider the Singvi Declaration, which was drafted by the former UN Subcommission of the United Nations on the Prevention of Discrimination and Protection of Minorities. There is a resolution there that requires states to take into account the principles detailed therein. So the Singh Declaration explicitly indicates that the legal profession, which is the profession we're dealing with in this case, must be open to all persons with requisite qualifications, and no one shall be denied such opportunity by reason of race, color, sex, religion, political or other opinion, natural, linguistic, social origin, property, income, birth, or status. Importantly, the declaration clarifies that every person having the necessary qualifications, integrity, and good character shall be entitled to become a lawyer and to continue to practice as a lawyer without discrimination on the grounds of race, color, sex, origin, religion, political, or other options such as nationality, linguistic, or social origin, property, income, birth, or status.
Advocate Bowe, I think your time to be not disturbed has gone. I think I can pose a question to you, if you don't mind.
Yes, Justice Mambo.
I've been listening very carefully to what you've been submitting regarding the right to work. And I think I'm understanding you to be saying the right to work of refugees in particular is being violated in this country. But I want to make sure I'm understanding you correctly. Are you saying that Section 22, which permits the restriction of access to one's profession, which is in our constitution, violates international law?
Justice Mlambo, our submission, oh, my apologies, there's some feedback. Our submission in this regard is that we don't seek to impugn Section 22. However, we proffer an interpretation that says, holistically looking at the rights that are at play in this case, Section 9 and 10, and having regard to the jurisprudence that says that Section 10, the right to dignity, should have read into it the provision of the right to work, that we can firmly locate an obligation on the state not to violate the right. And that Section 22 in its existence does not mean that other categories of persons who are implicated in this case do not enjoy the right to work at all, but rather safeguards it for citizens. And so in the court interpreting, we submit that it lies rather in a holistic looking of the rights at play and not necessarily impugning Section 22.
Yeah, but the right to work, as I understand this case and the arguments, is not an issue here. The issue is the right to access to the profession, isn't it?
Yes, Justice Mlambo, that is indeed the question before the court. And what we've tried to do in our submissions is first to identify that there is indeed a right to work, but also that in this right to work, it is work that one chooses. And we draw inspiration from non-binding instruments that come from the international community, because South Africa has ratified the ICSCR. So it is for the court to consider the level of weight that it gives to these instruments in interpreting the rights.
Okay, thank you very much, Justice Madlanga.
Thank you, Justice Mlambo. The last area of submissions that we choose to make is in relation to the right of choice of counsel. Justices, we note that the applicants in this matter have relied on sections 9 and 10. However, the ICJ submits that consideration must be given to the impact of the impugned provision on the rights of prospective clients who, but for this provision, could choose to engage legal services from persons in the position of the applicants. The
Sorry,
starting
Counsel,
point
could I ask you this? You seek to premise the argument on Article 7 of the African Charter as well. Yes, and as well as the principles and guidelines promulgated by the African Charter. Well, all of those seem to suggest that the right to counsel of your choice is only available from the pool of counsel who are available. And indeed, the principles of the African Commission speak of a foreign lawyer duly accredited to the National Bar. And so unless that hurdle is met, the right to counsel of your choice is not undermined, because everybody would have the right to counsel of their choice, provided that they were able to choose. Surely the right can't extend to persons beyond the pool of counsel who may at any given time be accredited.
Before you respond, your time is up, Ms. Bome. How much more time do you want?
Justice Madlanga, Justice Colopin's question falls right at the context of me dealing with why we make the submissions we make. So that after answering this question, that will be the conclusion of my submissions.
Thank you very much.
Justice Colopin, how we look at it is looking through the lens of Article 7.1c, as well as the principles and guidelines on the rights to a fair trial and legal assistance in Africa. And you are right that the principles in particular emphasize that the state must ensure that an accused or a party to a civil proceedings is represented by a lawyer of their own choice, including a foreign lawyer duly accredited to a national bar. We submit, Justice Colopin, that in understanding duly accredited and the meaning of a foreign lawyer, we must include the persons in the position of the applicant, because the people in the position of the applicants are all duly accredited, have studied in South Africa, have done their articles, and but for the bar to admission, haven't been admitted. And in a different context, if they were to be counsel who is accredited and admitted in a different country, they would be able to apply in South Africa for the same rights. And so that distinction we submit is unfair. And that is why we are asking for a broader reading of duly accredited and to expand the meaning of foreign lawyers in line with, of course, all of the submissions we've made about how the international law framework protects the various rights. Absent any further questions, Justices, we stress that the international law framework, as we've set out in our heads of argument, lend itself to a conclusion that Section 24(2)(b) of the Legal Practice Act is indeed unconstitutional and fall foul of the international obligations we've discussed. Those are our submissions. Thank you, Justice Maganga.
Thank you very much, Ms. Powe. Mr. Skakane.
Thank you, Justice Madlang. Justices, we intend making a few points because the debate has been held about different aspects of this debate. And the things we want to stress are the following. One is the nature of my client, Pabasa, and why its perspectives are important for this case. Secondly, we demonstrate to the court, because there's a debate about the floodgates that would be opened. We demonstrate to the court that our client that deals with the specific training of lawyers and what examples do they have, because we're not given evidence about this floodgate threat. And Pabasa seeks to assist the court by demonstrating through examples, because they have a school, the first of its kind, that deals with people who apply to do this. Lastly, while we align ourselves with the debates that have been held, we also submit that if one looks at the purpose of the Act, of the LP Legal Practice Act, it is in that context that we submit, lastly, that Section 24(2)(b) is inimical to the objectives, the purpose and objectives of that Act. We will limit ourselves to those three because the court has covered a wide range of issues with our learned friends who make the submissions that we agree with, particularly Mr. Bartlander, Mr. Mazibuba, and the other intervening parties. Perhaps before I start with the three topics, there's a question that was raised by Justice Matopo, debating with my learned friend, Mr. Mazibuba. And I think it's an important distinction to make because he asked the question, I mean, I forget the context, but he asked the question which I thought was hitting the nail right on the head, is this. A person who's legally here, trained here, fit and proper, but cannot be admitted. Is that reasonable? That person who's been trained here is not fit and proper. And we will link that at the end with what I call administration of justice arguments that we say are unjustified and some of them prejudicial. The first is this on Pabasa as an entity. As its name suggests, it's a Pan-Africanist bar, and the outlook seeks to enhance the objectives of the Act, which includes diversity. And if one looks at 3B of the Act, of the LPA Act, it also seeks to open access to justice. Pabasa also has a school, and it is this experience of the school that we want to highlight. The school trains prospective or aspirant advocates who are legally here. And as we have stated in the affidavits, there have been a number of advocates or prospective advocates who come here. They are here legally. Of course, unlike the other statutory bodies, we're stuck with not knowing whether to take their money, train them, and say, tough, you can't be admitted. PABASA gets 200 applications, sometimes more, per year. And of those applications, truly speaking, there would only 2 or 3 applicants that fall in the category that we are discussing today. And we've set those examples. In one example, they've had a good candidate who comes here, is legally here, is trained here, is fit and proper. And they are faced with the debate or the decision to make. Do we take this person knowing full well that at the end of the training, after taking his or her money, we will tell them, tough, you can't be admitted. And that is the essence of our argument here, is that the person who is legally here, trained here, fit and proper, can be admitted. And that admission does not subvert in any way the immigration regime.
The 5 minutes is up, Mrs. Kanema. You may put questions to you. Please continue.
Yes. Well, the last point that I want to make is a summary. Well,
sorry, Mr. Sikakane, could I just engage you on the submission you made earlier with regard to almost the expectation that you allow someone to study here, you allow them to enter into articles here, you train them here, and then you close the door to their admission. And you suggest that is both irrational and unfair. Could I ask you this question in that context? The Legal Practice Act is a product of Parliament, and it's administered by the Minister of Justice. All the other things you speak about, the admission of students to universities, the training, the articles, etc., are not the consequence of what the minister does or doesn't do. It's what universities do, it's what the Legal Practice Council do, it's what the bar does. Why should those factors, as it were, that are disconnected from the minister suggest that the minister's conduct then is unfair, unconstitutional, or Parliament acted unconstitutionally when they're not responsible for the other acts really that create the environment of unfairness?
Thank you, Justice Kolapen. I think that is where the difficulty is with this case, and the debate as I have followed it, is that a distinction is not made between a question of who can be admitted and the regime that determines who can work here later if they choose to do so. Our submission is that the question about fit and proper is the question about the person who must be admitted, who's been trained here, who meets the requirements. It is irrational to suggest that that person, because that is the end of the training. The end of the training is that this person is fit and proper. And of course, as I said right at the beginning, Justice Kolapen, nothing in answering that question suggests any subversion of the other statutes that determine immigration that must be complied with. We submit that it is irrational to suggest that the training ends there when the person says, can I be admitted, I'm fit and proper. And we get justifications, like some of them are absolutely outrageous, to suggest that the reason that they can't be admitted, and I'm not even talking about work, I'm talking about be admitted, is because they they may not have the highest ethical standards that a citizen has. There is absolutely no justification for such. It's what Mr. Butlander was calling xenophobic jokes. There is absolutely no reason why there should be a suggestion that that person, even if we didn't train that person, but I'm going to make the two arguments. We train the person in our universities. The person is fit and proper and then can't be admitted. in fact, I would go further to say it would be even prejudicial, even if a person was not trained here, to suggest that holding high ethical standards is a uniquely South African quality. It is so offensive and untrue. And therefore, those justifications do not answer the question. Why shouldn't we admit a person who's legally here, trained here, in the hope that if they comply with the regime that applies of immigration, they may well want to work here, and who knows, they may not want to work here. But the inquiry, Justice Kolapen, for me is it rational not to admit them when they meet all the requirements? And I submit that that is the end of the inquiry, and nothing in that inquiry that ends with admitting the person undermines or subverts the rights of citizens to work or all of the protections that the Constitution grants to a citizen. And our submission is that all of those justifications that are made do not offer any evidence. The second one is this. We set out in the affidavit the examples that demonstrate that Mr. Butlander made this point, but he was making a different point. We are actually dealing in most cases here with vulnerable people. We're not dealing with a group of Americans or anybody that just decide out of choice. I'm not saying they would be discriminated against, but I think it's important to note that whether we're dealing with refugees, asylum seekers, or people who come from across our borders, largely we deal with vulnerable people who come here, they're here legally, and they seek to survive. And to suggest that you can't even admit them when you've trained them, you can't even admit them, you say because they don't have the ethical standards that we have, it will undermine justice, administration of justice, and to suggest that they may leave. All of those justifications are not legitimate in our respectful submission. We therefore submit that our unique experience as the Pan-Africanist bar is that the floodgates argument is not supported by the evidence, because our evidence as the only bar and the first bar that is set up under the auspices of this act is that it is actually, it would enrich access to justice, to make, to include people we've trained, people who are here legally, and it does not undermine any the rights enshrined in Section 22 whatsoever. We submit that the justifications that have been given, they are not only inappropriate, some of them utterly shameful, to suggest low ethical standard by other human beings simply because they're from another country, and to suggest that they will leave, they'll pack up and leave clients stranded. Those two justifications, the court cannot take judicial notice of because they are not legitimate. And so our submission is this, is that if the court has to look at the cases that we've cited, which are the cases of this court, the Zondi case and the Hyundai case, we suggest that if the court wants to determine whether Section 24 meets constitutional muster, the purpose of the very act itself, the object and purpose, must be looked at carefully, must be studied as to what do we mean by transforming the legal profession to ensure diversity. Now, of course, you can take a narrow view that diversity simply means different ethnic groups and races that are citizens in South Africa. We have explained that citizenship itself must be looked at in the context of this changing world of borders that have become artificial because there is constant movement of people. And in the context of South Africa, that movement is not just constant movement caused by people's choices. It's also caused by people's conditions of war. I listened to the debate earlier about the permanence or not permanence of our asylum seekers or of that regime. Of course, Justice Ndambo was right, is that that regime itself implies that they're not permanent. And that as a matter of law is absolutely correct. What I would add to it, as I said right at the beginning, is that the object of the Act itself and our Constitution obliges us to take an approach of citizenship itself, to take an approach of transforming the legal profession and society to include people that would enrich our endeavors to ensure access to justice. And therefore, to exclude, in my respectful submission, to exclude people on these justifications is excluding enrichment of the rule of law, is excluding possibilities of real diversity in a world where globalization calls upon us not just to know what happens in South Africa, but to ensure that for the development of our law and the country, that diversity must include that we enrich our rule of law understanding with experiences from across our borders. Whether those people are here because they are desperate or because they choose to, it does not matter. Our submission is that this court must take the approach that looks at Section 24 as curtailing possibilities of diversity, access to justice. And in that respect, we submit that the justifications that have been made should be disregarded because they belong to the pre-constitutional era. The protections themselves, yes.
Sorry to stop you mid-sentence, Mrs. Kakan. At that point, your time is up. How much more time do you want?
Justice, I need 30 seconds.
Please continue.
To make the last point.
Thank you.
That Section 24(2)(b, we see it as a threat to the very objective of the Act. And if it is a threat as we submit to the Act, and it undermines equality and dignity of people who are here, vulnerable people in particular, it is unconstitutional. Our interpretation of it must be that it curtails diversity and access to justice. Those are our submissions.
Thank you very much, Mrs. Kakane. The court will adjourn and let us resume at 1:30. Court adjourn.
Court will adjourn until 1:30. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing commences at 1:30. Should you exit, you may use the same link to rejoin once the hearing commences.
Ms. Chitengu, are we not all back?
Justice Madlanga, I believe that we are missing Justice Matopo. Oh, Justice Matopo has just joined us. Justices, all counsel are online.
Thank you. Yes, Ms. Muroka.
Good afternoon, Justices. And on behalf of the first respondent, the Minister of Justice, we make the point right at the outset that we will not regurgitate our heads, but just set out the salient issues that we need to bring to your attention. And probably start off with, in a sense, expatiating on the importance of legal practitioners. Much has been made about the Union of Refugee Women and what the court found in that case, in the fact that the court indicated that there's a, I don't know whether it's my fault or somebody else's fault, there seems to be an echo that the security industry and the legal profession is different. We would submit that indeed the two are different, but at the same time, assert that lawyers play a very important role in society, serving both the interests of the public and individuals, and that the profession is worthy of protection. It must be an independent profession. And if one has regard to what the Legal Practice Act has to say, and possibly if I may start off by referring to what we say at paragraph 51 of our heads, we make the point that in interpreting the Constitution and attendant legislation, we must do so in a contextual manner and refer to what Judge Ngobo said in Matatiele Municipality versus the President of South Africa at paragraph 37, where the justice, that is before he was Chief Justice, had this to say, that the proper approach to constitutional interpretation involves a combination of textual approach and structural approach, and that in construing the provisions of the Constitution, it is not sufficient to focus only on the ordinary or textual meaning, but that the Constitution must be construed purposefully and in light of the history, and in fact that the history of the Constitution, the history of the country must not be ignored. And I say this because there's been a sense that government and government policies have a tendency to promote xenophobia. And I want to
just at that point, Ms. Muroka, colleagues, please be reminded that Ms. Muroka said she may be interrupted right from the onset. Please continue, Ms. Muroka.
I did say I didn't need protection, Justice Madlanga, and I appreciate the time. But when we look at what the Legal Practice Act has to say, before I go to the gravamen of this case, I just wanted to sketch a scenario about the Legal Practice Act and the fact that it was an act that sought to bring a change to how access is achieved, how redress is achieved, to how we as a people intend moving forward with the profession. And it does say that in bearing in mind that the access to legal services is not a reality to most South Africans. It's all very well when you talk about floodgates and say that we have not put forward evidence that indicates that there will be floodgates, just to pause and recognize that the Legal Practice Act does recognize that the past was construed and managed structurally in such a way that a particular section of the population was not given access, was not encouraged, was not empowered, and that the landscape did not, well, such that most South Africans were entitled to practice the profession of law. And that therefore, that recognition is made in the Act itself. And that the legal profession must be broadly representative of the demographics of South Africa. That was put into this Act because of the reality of what confronted all of us in the profession. And therefore, the fact is that we cannot ignore or seek to minimize what it is that the Legal Practice Act sought to do. And not forgetting the fact that the Legal Practice Act was debated, that professionals amongst ourselves got themselves involved in trying to change the landscape of the legal profession.
Ms. Moroka?
Yes.
Just to interrupt you. You don't have to deal with this question now, but I think that it bears some relevance on what you are arguing. It is the submissions that have been made to counteract your submissions on legitimate governmental purpose. The first one, and it concerns me, is the fact that practitioners who are foreign nationals and who have qualified outside of the country are permitted to practice in the country, whilst those who have not been admitted are not. And as I understand the point that is made there is that there can be no legitimate governmental purpose in that differentiation, because even those who are allowed, that is those who have been admitted in their countries, are still not South Africans. That's the first concern I have. And the second one is, and correct me if I'm wrong on this one, because as I was reflecting, I thought that for as long as legal graduates are not seeking admission, they can go out there, for instance, in the corporate world and work as consultants or as legal advisors, as long as they don't seek admission. How do those, can you comment on those?
If I may, then I'll go back to my address. With the first issue of foreign practitioners, it really has to do with reciprocal agreements between states. That's the first issue, and GATS. And the fact that we are signatories to international cooperation agreements, and that's the first one. And the second one is that where we have designated certain countries, we're able to appear in those countries, and they in turn are able to appear in South Africa. It has to do with international relationships. It's a policy decision, and I would submit that it is part of our obligations and part of a recognition that the world is an open place where we need to have inter-country and intercontinental relationships. And that is why, for instance, we subscribe we're signatories to GATS, to the extent that foreign foreign lawyers or foreign practitioners can come and practice in South Africa, and were entitled also to go and practice in those jurisdictions.
But does that submission answer the fact that those who have not been admitted in those designated countries, but have qualified here, that is studied here and did their articles here, even if they come from those designated jurisdictions, they are not entitled to be admitted?
Because there is a process that has to be undertaken. You have to apply for admission in your own country. And I would imagine that there would be legal qualifications that you have to comply with to be admitted in your own country, in the same way that there are qualification criteria in our country. So they come into the country having passed that test, or having passed the hurdle that they are now practitioners in their own country, and they have been vetted to be practitioners in their own country and are able, therefore, then to be recognized in our country.
I think my problem really is on the purpose. What is the purpose? What is the governmental purpose of that distinction?
The governmental purpose is, as I said, is reciprocal recognition. And most countries do it. That is why, I'm sorry, our last minute. And
I'm sorry, I'm
sorry, Judge.
I'm sorry, Ms. Moroka. I'm more interested on the governmental purpose of the distinction between these two groups, those groups who have been admitted in the country, in their own countries, that is the designated countries, and those who have not yet been admitted in those designated countries. I do understand the international relations and submission and all of that, but I'm more concerned about the distinction between these two categories.
Because for one, they have been vetted in their own countries. They are resident in their own countries or citizens of their own countries, and they have qualified in terms of the provisions that apply there. Either whether they are, the provisions say, as some of SADC countries would say, ordinarily resident or citizen, and other countries would say you have to be a citizen. They have qualified in terms of the prevailing legislation in those countries. That's the first thing. And there's a jurisdictional issue that I'm going to address about the fact that, for instance, the LPC is concerned with accountability. And in those foreign practitioners would have their own, as it were, their own LPC, having jurisdiction over them, excuse me, for whatever purpose, if in the same way that you would have disciplinary provisions in our act, I would imagine they have disciplinary provisions in their acts. Therefore, those regulators are able to exercise jurisdiction over those people. And that is why there's a comfort in terms of accountability, that we have the comfort that their own regulators are able to exercise jurisdiction over these people, and therefore accountability in the public good is able to be exercised. And that would be the distinction. And if I were to say that there's a distinction between them and the people that are the applicants in this matter, the applicants in these matters were given special dispensation. And in terms of the Immigration Act, they were not subject to any checks. They were not subject to any conditions. All that happened is that you have these numbers of people that came into South Africa. And because undocumented, and because on humanitarian grounds, you had to make a decision about them, you then decided to give them special permission or special permits without any vetting, without any checks, criminal checks. You could be giving, and this is not to say that we are casting aspersions. We do know that there have been warlords who've been given sanctuary in South Africa and had to be turned back to their own countries. But because you haven't vetted them, as you do, for instance, with refugees, you just gave them a special dispensation. Whereas, as you mentioned, the legal practitioners in those other countries have been vetted by their own regulators, and that therein lies the distinction. And you have to be accountable to somebody. And part of it is what we say the Legal Practice Act seeks to do. It says that it has to regulate the profession in the public interest. You can't do that if you are not able to exercise oversight over those people because the status is unsettled. I hope I have answered that one.
Excuse me, Mrs. Moroka.
Sorry, Justice Matopo, I was trying to figure out whether I've answered. I think Justice Chiku, you asked me a question about legal graduates.
Yes.
Oh, sorry,
yes.
sorry, Justice Chiku. I'm sorry.
My apologies. You asked about, I can't recall the question.
I asked about legal graduates who would then, and again, it was talking to a legitimate governmental purpose. Legal graduates would then complete their LLB or LLM and then go and be employed as consultants, etc. And I think this question talks to job reservation.
When you say the question talks to job reservation, Justice Chiku, what we are saying, and we say it in our head, is that the section in the LPA Act does not prohibit all these graduates from working. It certainly does not prevent them from getting work. What it does, it says you have to be a citizen or a permanent resident to practice law or to be enrolled as a practitioner. That's all that it does. It doesn't reserve any other profession that you would seek to engage in. It just says you have made the choice to study law. You have made the choice to complete your vocational training. We have the choice in terms of the Constitution and the law to reserve the practice of law and the enrollment of law in the Constitution to citizens and in the LPA to citizens and permanent residents. But you are at liberty to work anywhere where you would want to work. And we would say to you, Justice Chiku, that the limitation that is contained in Section 22 of the Constitution is a recognized limitation where every country has the right to delineate and to assign only to its citizens the right of choice. And this speaks to the right of choice. Not the right to be employed, but the right to choose what profession you want to follow. The right to work is not limited. The ZEP and the Lesotho permits do not limit your right to work or engage in any profession. What it does, it limits, in terms of the LPA Act, your choice, your specific choice. And by the way, even though it limits it, at a point, for instance, the ZEP and the Lesotho permits are, the government has declared that these are coming to an end in 2021 at the end of the year, 2022, which then means they have a right, in essence, to apply for permanent residency. And having the right to apply for permanent residency or any other permit, they would then qualify in terms of Section 24, they would then qualify. And the notion that it takes a long time to qualify is not an answer to that entitlement, because you don't change a law because there are structural problems or process problems with the Department of Home Affairs. The fact of the matter is, once your ZEP entitlement comes to an end at the end of the year, you either go home or you apply for a different permit. And that different permit might in turn allow you or entitle you to apply for permanent residence.
Justice Madlanga, thank you.
Thank you, my sister. My brother, Justice Matopo.
I pass for now.
Please continue, Ms. Moroka.
Ms. Moroka, still on the government purpose, I just want to find out something. You say the government purpose is to protect the struggling law graduates to secure employment. Then you bring in, what I would like to know is, if that is the case, why are the foreign nationals allowed to do the vocational training if the purpose is to protect the struggling law graduates to secure employment?
I said, Justice Center, that when you interpret the Act, interpret it from a historic perspective. That's the point that I was trying to make, that you can't divorce what has happened in the country. Excuse me. And that is why our numbers are different. That is why even at the bar, the numbers are different. That is why at the sidebar, the numbers are different. And I don't think there's any gainsaying the fact that more than 60% of lawyers in this country are from a particular group, and the minority are from a particular group. And I'm saying that the Act sought to redress that. And I'm saying, therefore, that when a foreign national applies for a work permit, I mean, for a study permit, they're given the right to come and study. The Rafoneke, for instance, says, I made a decision to come to South Africa, and I decided to make South Africa my home. What then did I do? I applied to study law at the University of the Free State. After that, I went for articles and I went for practical legal training.
My question, though, excuse me, Ms. Moroka, my question is, you allow this person to undergo the training. Now, when the person says, I would like to be admitted, you say, no, you cannot be admitted. What was the point of allowing the person?
But it was a work permit. It was a study permit. It had nothing to do, the law was the law. It had nothing to do with whether at the end of your study, when you're going to be allowed or permitted to get admitted. You applied for a study visa, we gave you a study visa. You do not say, by the way, I apply for this study visa, and at the end of the study visa, beware that I want to be admitted as an attorney. The law did not permit. And Ms. Rafoneke should have known that the law does not permit. But at the same time, the law doesn't say once you have done all of that, all avenues are closed to you. You can't do anything else. You choose your profession, and you choose to come into the country and abide by the laws of the country. What you could have done is you could have applied for the study permit, gone home, because, for instance, with Ms. Rafoneke, she doesn't tell you on the papers that I can't go home. So she could have gone home and applied for a work permit and come into the country. But you can't, under the auspices of a general dispensation that clearly sets out the conditions of that dispensation, ignore that dispensation, go ahead and study, go ahead and do your vocational training under that dispensation. And when you are done, you say, actually, I don't like this dispensation. I want now to be an attorney, despite the fact that that dispensation was conditional. That's the point that we're making.
Thank you.
And I'm saying you're not barred from doing anything else, because you must have known when you decided to come and make South Africa your home, that there were laws, there were immigration laws, there were employment laws, there was the Constitution, there was the LPA that delineated your rights and entitlements.
The applicant said that The applicants are saying that you must divorce the two, the immigration laws, put them one side, deal with what is contained in the LPA, the section 24, and ask the question whether it's rational to exclude these particular people. What happens under immigration laws is something else. What is your response to that?
Our response is, and we said it in Bloemfontein, and we insist on that response, that you granted what they're looking at is the four corners of the LPA. But they must assert that they have been given permits in terms of an immigration dispensation. They can't divorce themselves from that dispensation. It was given to them. The Immigration Act is in existence. The Employment Services Act is in existence. You can't ignore that. Because the issue that you rightly ask is, you then get admitted. What then? They haven't been able to answer that question. So it's a battle for another day. But they are all interlinked. I do believe that you cannot read one act in isolation from another. You can't read the provisions of the Constitution in isolation from each other. They are mutually reinforcing. The laws, we would imagine that the laws shouldn't be in conflict with each other. And we are asking you not to read the laws as if they're in conflict with each other. They are not. They were given a special dispensation that was conditional, and they do not have, in terms of the Constitution, a right of choice. They have a right to work, but not a right to choose what kind of work they do.
Thank you,
just my talk.
Ms. Moroka, would your argument be the same in relation to refugees and asylum seekers who, through no fault of their own, because of what is happening in their countries, happen to find themselves here? And we know that they have a right to live here and to work here. And if that right to work here precludes or excludes them from being admitted and enrolled to practice as attorneys, what is it that they can do if there is such a bar or impediment? They've been in the country, say, for example, more or less the same number of years, 8 to 10 years, that's eligible to apply for permanent residence. And they haven't applied. Would you say they must wait their turn and they must await the outcome of the application before the Home Affairs, before they can consider launching any application for the admission or enrollment?
Can I say, Justice Matopa, if I may, distinguish between asylum seekers and refugees? If I may, for the moment, talk to refugees and say that refugees have an entitlement. It's not as if asylum seekers have not gotten an entitlement, but you must recognize that they are treated in the law differently. Even in the Refugee Act, they're treated differently because refugees are recognized as being a system in place to in a sense, establish their refugee status. And now as refugee asylum seekers, they are now moved into a refugee status position. Their position is not a permanent position. As it was rightly pointed out by one of the justices, like at a point, it might be that they can go back home, or it might be that their status is determined to be indefinite, and therefore they're entitled to permanent residence. And in that instance, if they are so entitled, they're entitled to permanent residence, they're entitled to apply for permanent residence, they're entitled to apply for admission and enrollment. That really is the answer. And indeed, in fact, in terms of the Union of Refugee Women, it's the same kind of scenario, that there is an entitlement that they are entitled to, but it must be according to what the law states about their status. I've been referred to.
Sorry, Ms. Moroka, can I Sorry, if you're done, Justice Matopo. Good. Ms. Moraka, can I raise a question on a sort of tangential issue, but it worries me. So,
sorry, Justice Kolapin, can I finish answering Justice Matopo? I really apologize.
My apologies, Ms. Moraka. I thought you were done. Sorry. Yeah.
It's a question about waiting your turn. If I can reference to Union of Refugee Women at paragraph 50, where it was held that the applicants may also, in terms of the Immigration Act, read with the Refugee Act, acquire permanent resident status in due course, like other refugees, thereby complying with the requirements of the Security Act and qualifying to enter the industry. The same can be said about the applicants. Well, we don't have applicants, refugee applicants, and therein also lies our difficulty. That we have affidavits of people that we haven't responded to, and we're told that the evidence is uncontroverted. Our difficulty is that we pointed out that you would have to what's the word, join the Home Affairs people, because we wouldn't have that information. We can't respond to it. But having said that, we're saying to you that paragraph 50 seems to answer your question. Thank you. Justice Kolapin.
Thank you, Ms. Moraka. Ms. Moraka, the Attorneys Act and the Advocates Act, which have since been repealed, had similar gatekeeping provisions that you could only be admitted if you were a citizen or a permanent resident. However, both those pieces of legislation had a provision that if you ceased to be a permanent resident or if you ceased to be a citizen, you could then be removed from the role, which would seem to be logical, because if the conditions for your entry were no longer valid, you could be removed from the role. However, the Legal Practice Act did not provide for those similar provisions in its current formulation. What it does only do is it provides for your removal, and it provides that the Legal Practice Council may suspend somebody if they were erroneously enrolled or if they were enrolled on information which subsequently proves to be false. So from that, it would appear that the current system for the removal of a practitioner is really based on the common law, that if you're no longer a fit and proper person, and we know how courts deal with removals, it's really largely based on the conduct of an individual as opposed to their status. So it seems to me that there might be a disjuncture in the law, in a sense that if you enter on the basis of being a citizen or a permanent resident, you become enrolled. But if your status should change, then you stay on the roll, because there's no provision in law for your removal, except if you're not fit and proper, and that wouldn't apply to someone who's lost permanent residence or lost citizenship. And therefore, you have this odd situation that if you're on the roll, and even though your status will change, you stay on the roll. But if you're not on the roll, and even if you're of that same status, you can't get onto the roll. Do you wish to comment on that?
I haven't had time to look at those provisions, but I would say on the top of my head, Justice Kolapin, that if your status is that you have been, in terms, I would imagine, of the Immigration Act, you're no longer a citizen, and you're no longer a permanent resident. The consequence of that is that you must leave the country, because in essence, you're now unlawful, or
not necessarily, Ms. Moraka. You could cease to be a permanent resident, but you still could continue to be lawfully resident in the country. So you're not required to leave the country.
But I would imagine if the LPC were to do their job properly, they would have notice of the fact that you're no longer a permanent resident, and would have cause to entitle them to remove you because you don't qualify in terms of that section.
Okay, I only ask because the Act is silent on that in comparison to the provisions that existed in the Attorneys Act and the Advocates Act, which have since been repealed. Yeah. Okay.
It is an interesting one, Justice Colopin. I don't have an answer for it, but I would imagine, as you say, in terms of the common law, I would imagine that the LPC would retain the right to regulate in those circumstances.
Ms. Barocca, you probably heard my questions to Mr. Budlander, and I wanted to just ask you this question. Since the statute permits of the admission of permanent residents, Mr. Budlander made the submission that there would seem to be no justification for excluding categories of persons who are similarly situated. In other words, have the right to live and work in South Africa and have done so for lengthy periods of time and are essentially have what I call a fixity of connection, and so might be thought of as ordinarily resident. And he said, well, there's no justification has been given to distinguish their position from the position of permanent residents. What do you say about that proposition?
Justice Unterhalter, we move from the basis that whatever status there is underpinned by provisions of the law. You have a group of people who have got special dispensation, and that is what it is. There is no provision in the Immigration Act except the discretion of if I'm not mistaken, the Minister of the Director General. That is it's not a permanent state. And that is why you see that at the end of this year, those people who had been given that dispensation must find a way of staying in the country or leaving the country. So the question that they're similarly situated, I would submit, is not a correct comparison. When you apply for permanent residence, you apply on a particular form. You must go through the proper, I don't want to call it interrogation, but questions about that status that you seek. And you must satisfy the government that you indeed are entitled to do so.
But Ms. Barocca, you're looking at this through the prism of the Immigration Act. We've got to determine the constitutionality of the Legal Practice Act. And the point that is being made, and has been made by a number of your opponents, is to say, well, if the law under the Act allows for permanent residents who are not citizens to have the benefit of admission, if there are categories of persons who are indistinguishable, not because of the construction of the Immigration Act, but because they are, for all intents and purposes, living in this country and mean and can do so pretty much in perpetuity, why are we discriminating against them? I think that's the point.
But I'm trying to answer that by saying, but that is not the correct factual premise, because they're not here indefinitely in perpetuity. There's their condition that you've been told that we're giving you this as a dispensation which is going to come to an end. And indeed, government has decided that it is coming to an end. When we give you permanent residence, I mean, all the cases that have been alluded to, be it Union of Refugees, be it the affordable medicine, be it the Canadian case, all of them speak to permanent residence as opposed to other forms of residency. And I'm saying, Justice Unterhalter, that from a factual perspective, it is not correct to compare permanent residency with ZEP dispensation. It is not correct. They are not here on a permanent basis. They're not here. They're here on the mercy of the state, to the extent that the state recognizes that for a period of time, these people needed to be recognized. They are undocumented. There's a number of them, and indeed to ameliorate their condition, we're going to give them these permits. It was never the intention that these permits will be equal to permanent residency or permanent sojourn in the country. That was never the intention. And those extensions, because there have been extensions, they've been on humanitarian ground. And therefore, to compare that humanitarian dispensation with permanent residency, I would submit is not correct.
Yes, thank you.
Ms. Morocco, can I turn to another aspect, please? Union of Refugee Women is said to be distinguishable, so the applicants say, on the basis that their section 23.6 saved section 23.1, which was the impugn provision, saved it from overbreadth and potential unconstitutionality, because it allowed for a certain degree of flexibility of discretion for an exemption, and that's absent in this particular statute, in this section. And also, I think the Rafoneke applicants, they also make a second submission. They say, furthermore, over and above that, Union of Refugee Women is distinguishable because it does not have a similar sort of regime as in section 115, which makes provision for this accreditation, for this reciprocity at international level. So the two are distinguishable, and Union of Refugee Women doesn't really assist the minister's case. What do you say about those submissions?
Indeed, the Union of Refugee case, the section was saved because of section 23. But we would submit that the act as it stands does not completely preclude these aspirant lawyers, as it were, if I may call them that, from working and being employed in other provisions of prominence for instance, if you're going to be a legal advisor, if you're going to be a consultant, if you're going to have the entitlement to do other things other than being a lawyer, in fact, I would prefer that to being here. There is no reason why there should be that provision. But if we are wrong in that instance, that it can only pass constitutional muster if there is a provision akin to that one, we would then ask that it be sent back to Parliament for Parliament to review to that limited extent. That would you give the power to the minister or the power to the regulator to say on good cause shown there can be a deviation. But having said that, we don't believe that because there is no deviation, that it doesn't pass constitutional muster. There is a choice that was made. The choice in our view passes muster, and therefore that there is nothing unconstitutional about that section of the LPA.
How does your response, Ms. Morocco, affect Ms. Makombe, who is also has passed her notary and conveyance exams?
But Ms. Makombe must have known, as she did that, Justice Majid, that she first needed to be an attorney before she could do the notary and conveyancing exam. That she knew. She took a choice. She made it despite what the law says. Those three pieces of legislation, she took a choice to say, I will study. somebody said, with the hope that one day I will be able to be admitted. We say there is the possibility that she will be admitted, but that possibility must be in terms of the law. She must apply for permanent residency. She must be a citizen. Those avenues are open to her. But she cannot jump the loop of being an attorney to say, never mind the fact that I can't be an attorney, just make me a notary or a conveyance. You must first be an attorney. You must first bring yourself under the rubric of being an attorney, being under the authority of the LPA or LPC.
These special dispensations, they are more or less the same, the LEP and the ZEP, as far as I can see. But were there any restrictions on what you could come and do in South Africa? For example, were there any restrictions that you could only study, that you could only work in certain sectors, or the like? Were there any restrictions whatsoever in terms of these special dispensations?
There were no restrictions. There were no restrictions, but if you're going to study law, we would submit that you must know what the laws of the country require of you. There were no restrictions because I think from a humanitarian perspective, we accepted that these people must study. We accepted that they're entitled to study and to work, but that the restrictions had to do, in essence, with their immigration status and whether they could move from one regime to another regime, given the fact that there was no process that could verify any of the information that they gave.
And then just lastly from me, Ms. Maroka, there's an argument, a strong argument from all the applicants that you permit these applicants to come here, to live here, to work here, to do their articles here, to write the admission exams. And then when it has to come to the point where they have to be admitted as attorneys, you say to them they cannot do so in terms of the provisions of the Act, impugn provision. The submission is that says to them that they are unworthy and it infringes their right to dignity. What do you say about that argument?
I don't believe that is a sustainable argument. We don't make that point. Somewhere we are told that we said they can be trusted. That's far from the point. The point that we made is that we needed accountability and oversight. That's the point that the minister made. But what the point that we make is that we give you a permit to come and study. We give you a special dispensation. And in this dispensation, you have a wide choice. You can study, you can then do vocational training. But to do any other thing, to be, for instance, a security officer or to be a lawyer, you must, at the very least, comply or do so in terms of the applicable legislation. You can't be a security officer, even if you've trained to be a security officer, because the law doesn't permit you to do it. You can't be a lawyer, even if we've given you permission, because the law doesn't allow you to do that. And we're saying to you, Justice, we have given you this open book from which to choose. But what we haven't given you in terms of Section 22 of the Constitution is the right to choose a profession. That right we have not given you. We've given you everything else. And it is for you to decide what you want to do with what we've given you. And you can have that right once you comply, once you apply for permanent residence, or as Tate Mutsuenyane can, he's got a spousal visa. It's not very clear what he applied before the spousal visa was. He was entitled to apply for spousal visa. He can do so. And he's finished the 5 years, he can apply for permanent residence on the basis that he's been married to one person and has lived in South Africa for a period of over 5 years. He can do so.
Ms. Maroka.
Thank you, Ms. Maroka. Thank you, Justice Matlanga.
Thank you. Ms. Maroka, besides the possible argument that you should know that you ought not to do articles if you are not going to be admitted, is there anything in law that says non-citizens may not do articles?
No, there isn't, Justice Madam. There isn't.
I'm raising this because I'm looking at the reasons given by the minister in volume 3, pages 203 to 205. I will focus on paragraph 38, where this is said. In this regard, the LSSA stated as follows, quote, a blanket provision for foreigners to qualify will have a negative impact on many graduates who find it difficult to secure articles, please underline, secure articles of clerkship or community service for purpose of qualification. It seems to me that at face value, there is an inconsistency, if not contradiction, in what the minister is raising. Because if there is a concern, even at the level of getting concern for South Africans, even at the level of getting articles, why is it that the bar or barrier is not at that very point? You cannot even do articles. Does this not put to question the very idea that this is one of the purposes for barring non-citizens from entering the profession?
Justice Madlanga, I made a different point when I started off. And that was the point about access. And to be blunt, the point about access for Black people into the profession. If anyone amongst us were to dispute that there is that issue and there is that problem, I'd say they must be living in a different world. But what we say at paragraph 38, and we are saying this is what this LSSA is saying. Because if you recall, there was a lot of consultation when the LPA was being formulated, a lot of debate, a lot of to and froing between all sectors of the legal profession, be it NADEL, be it BLA, be it LSSA, be it the task team. We know that it took years to get this LPA into place because there were different and differing interest groups about it. And the intention was that if we could get to an act that would, at the very least, satisfy all the parties, not satisfy them in every respect, but satisfy the parties. And therefore, part of what the LSSA said was this. But this does not find expression in the Act. It doesn't find expression in the permits that are granted to the people. It is just a concern that the LSSA articulated. And it is a concern that's articulated in the Act, as I've pointed out. But that doesn't mean that the students who wanted to study the law were barred from doing so. It just meant that they were allowed to do so because it opens a whole host of avenues for them. And you don't bar them just because you say you cannot be a lawyer. You can be a host of other things other than a lawyer or other than an admitted thing.
But I thought the minister adopts this. Well off the top of my head now, I will not be able to take you to the exact spot or exact pin site. But in the minister's written submissions, I think it's in the context of the Section 36 justification exercise. Reference is actually made to this, I think. You know, the numbers, the issues, the issues around entry for South Africans because of the numbers involved and so on. So I do not think you can relegate it this easily.
No, Justice Madlanga, what I am saying is that we're giving you a position of what the LSSA said. We even give you the statistics according to what the LSSA says about the difficulties of getting articles. But that doesn't.
But my question then relates to, perhaps I should be more direct. Are you now saying that for purposes of the Section 36 justification exercise, the minister is not adopting this?
No, the minister, what the minister said in 65.3 at page 32 of the head is that the LSSA was not in favor of a blanket permission for non-citizens to practice. And the legislature took cognizance of that fact. What we are saying is we assert that even today, Justice Madlang, that we have a choice. I mean, Section 22 says you can have a choice. That choice must be grounded in legitimacy. We are saying to you that in terms of Section 22, the LPA has retained the right to legislate for Section 24. And we are saying to you, in terms of Section 22 of the Constitution, there is nothing wrong with doing that. It is premised on Section 22. It is premised on a historical context that says broaden access. But that broadening of access does not mean you then do not give other people the chance to qualify and have degrees in those disciplines. What it is that we then say, and they do struggle to get articles. We're not saying they don't struggle. We're not saying young Black people don't struggle. And to request or insist that we give you that statistics, I think the Free State judges took judicial notice of the fact that Black people, young Black people, do struggle to get articles. But that does not mean it's a justification for saying don't study law. What we are saying is when you make the decision to study law, do it with the recognition that the Act says you're not going to be admitted. That's what we're saying.
Maybe then to understand.
I'm sorry. I'm saying until you get permanent residence or citizenship, and you're not barred from doing that, except that ZEP and LEP say you can't do it. You would have to follow the immigration laws to get that permanent residence.
Yeah. Perhaps to understand your response to my questions, let me ask you to please articulate the minister's justification then in terms of Section 36. What exactly is the minister's justification and what is it founded on?
Perhaps if I can be allowed to take a step back and say that in terms of Section 22, we do not believe that there is discrimination.
You don't believe that there's what?
We don't believe that there is discrimination. We say there's differentiation.
For purposes of this debate, for purposes of this debate, let's just assume, the two-stage process. Let's just assume that there is a limitation, whatever the basis may be. I want us to zoom in on justification. So, and I'm saying, please, I want to understand exactly what the minister says with regard to, please just itemize the bases, plural, for justification.
Yeah. I will do so, Justice Madlang, and we do it at page 31, at paragraph 65.2. We say that government has an obligation, and part of that obligation is an entitlement, an obligation to say citizens first in choice of employment. And we say once that is done, we say, and part of it is to protect the public. And we say to protect the public not because we are assuming that the LEP person and the ZEP are by their nature untrustworthy. We're saying accountability because of the kind of permit that they have is difficult. And then we say what we also say is that you do have to take into account, given who we are in this country, our socioeconomic condition. And we are saying to you, there's a policy imperative to be cognizant of the fact that South Africa is a developing state. And in terms, I think, of article, I will look for it now, we're entitled to take into account, as we develop, socioeconomic conditions in the country. So therefore, we're saying to you, and in light of the Employment Services Act, that when we look at the entire conspectum, is that we say that while we will admit people to do to undertake certain professions and to have choices, we accept that they can do so, but having in mind the fact that law is not a critical skill. Unfortunately, we would love to think we're very important, we're very clever, but law is not a critical skill in terms of government policy. And therefore, as we put those barriers and as we make choices, we make choices about who to admit into a country, for what purpose, and for what exposure. And therefore, we are saying the government is entitled to take those socioeconomic conditions into account, underpinned by the fact that we're giving you the right to be employed, but we're not giving you the right to choose. That's really what we're saying. We're not giving you the right to choose which profession, but we're giving you the right to study whatever you want to study, the right to be vocationally trained, but you're not a critical resource. So we will not give you that right. And fourthly, we took into account the fact of what are our stakeholders and the most important stakeholders saying about this provision in the Act, and the fact that if you want redress, and I take Mr. Skakani's view that access enriches all of us, and I can't take that away from that point, that access enriches, being able to have our counterpart.
Please let me know when you are done with responding to me. Eh?
I'm still responding to you. I'm saying,
thank you.
Those are the things that I'm mentioning. That
yeah, I'm not at all. Yes, I'm not at all suggesting that you are being irrelevant. No. Say, please let me know. Yes.
we are saying redress is an issue, and it's an issue for this country. And I think all of us are very passionate about the issues of redress. At the same time, as we look at redress, we don't intend to discriminate, as it were, against our African brothers and sisters. But what we're saying is, as we do that, we do it in terms of the law, we do it in terms of government policy, and we do it as a developmental state that must take into account our socio-economic condition. That's all we're saying. And we point out that to the International Covenant on Economic and Cultural Rights, that gives us really, when you talk about developing countries, we must have due regard to our economic circumstances. And therefore, that is why it has been recognized that developing countries must do it within the parameters of what they can do, what their challenges are, and how they confront redress.
Thank you, Ms. Moroka.
I hope I wasn't relevant. Thank you.
No. As I said, I was not at all suggesting that, but I just wanted to be sure, because what I wanted to do was to tell you that your time is long up. 3 minutes beyond. How much more time do you want, Ms. Moroka?
All I can talk to Justice Madlanga, I nearly called you Chief Justice, is really that we at page 47, we talk about remedy. But we talk about remedy in the context that the judiciary must give due deference to Parliament. Well, firstly, let's say that we are not of the view that the provisions of Section 24 are unconstitutional, but that if you are not with us on that point, we would urge the court to send the matter back to Parliament so that a reasoned engagement can take place, a reasoned engagement between all stakeholders about which way do we want to amend, read in, read out, so that we don't
just so we have an idea of the parameters. How much more time do you want?
Oh, no, in fact, I was at the end. That whatever 2 minutes, whatever it is that the court decides, it must decide not to correct failings about how long it takes for our visitors, as it were, our permanent visitors or our semi-permanent visitors, that because they have problems about applying for permanent residence, we try and fix by then trying to amend the law. In that if there is a need to amend, then the issue is it has to be sent back to Parliament to review, to evaluate, and to correct and determine which is the proper way and the proper route for South Africa to take. That would be my submissions.
Thank you very much, Ms. Moroka. Yes, Mr. Snellenberg.
Thank you, Justices. Justice, may I just start by just reiterating that making submissions in an affidavit and making it in a manner that that could have been put better, more sensitively in an emotionally charged case like this, still doesn't amount to xenophobia. It is so. The LPC in the Rafoneke matter in Bloemfontein filed an explanatory affidavit, and a different team in Pretoria then received the other challenge, and there it was decided to oppose the matter based on whatever considerations. But when all these applications for intervention and so forth came, it was always more convenient for the LPC to have one team to represent them. So we are in a peculiar position, I think, as enumerated, in the sense that the position taken in both cases or in both affidavits, all the affidavits are, however, the same. And that is that we are here Custos Morum. We make submissions, and we have done so hopefully in our heads, responsibly and in terms of the law. And if I can then immediately move away from that. Now, Justices, just to, I say you should never start a conversation by stating the obvious, but to test whether a provision is unconstitutional, we obviously measure it against the Constitution. Now, you would have noted that the applicants, Rafoneke, started quite strongly by saying that we are only concerned with admission as a legal practitioner, but not claiming an entitlement to then work. But as the arguments progressed, the right to live and work in the Republic became a predominant submission and feature of the addresses by our learned colleagues on behalf of the intervening as well as the Amicus parties. And we made the point in our heads with regards to Rafoneke that it is a somewhat artificial distinction, and we say it with respect, to say that being admitted as legal practitioner in light of the provisions of the Act, it says you are immediately entitled to practice as a legal practitioner, be it as an attorney or an advocate or anything else, means that you are entitled to work even if you do one single conveyance, for example. Now, we would like to just start the inquiry at a slightly different point of departure. Section 22, and it's been repeatedly referred to, but for purposes of our argument, if you would just allow me to quickly just quote it again, limits to citizens and provides that every citizen has the right to choose their trade, occupation, or profession freely. Then it says the practice of a trade, so the performance thereof, or occupation or profession may be regulated by law. Now, Section 22, in express terms, reserves the right to choose, in this case, a profession to citizens. So some of the cases that we refer to and the other, our colleagues refer to, dealt with issues such as social grants, where this court was called upon to consider whether the term everyone is entitled to would include certain classes of people, be it foreign nationals, be it refugees, and so forth. But here, we don't have to go through that exercise because Section 22 itself is expressly limits us the choice of profession. Now, we must remember, Justices, that Section 22 formed part of the Constitution, which formed part of the final certification process, where this court determined and was called upon to determine whether the Constitution, as amended in its final proposed form, complied fully with the requirements of Schedule 4 of the interim Constitution. And during that process, we respectfully submit that the Constitutional Court would have taken all the considerations into all the factors into consideration that, for instance, was later set out in Larbi, Odom, and others, for example, because Section 22 in its certified and adopted form implies by its very nature already that if you are not a citizen and you do not have a right of choice, then your dignity to extent and your right to equality is already limited by the section itself. There's already an impairment of it. And in the certification case, as Justice, you know well, the court inter alia considered various instrumental instruments and other constitutions and came to the conclusion that this limitation and the right of a sovereign nation, which we are, to reserve the choice of trade, occupation, or profession to citizens is not unconstitutionally invalid. And so Section 22 found its way into the Constitution. And it says what it says. Now, you have been referred to Union of Refugee Women versus Director. Obviously, it's a case that is of prominent importance to all the parties in this matter because it gives direction. But Justices, we read it slightly different from some of the submissions that you've had, because in no uncertain terms, the court held in Union Refugee Women that assuming that the differentiation was indeed discrimination, and that such discrimination was, when such discrimination would not be unfair, since the activity for which the applicant sought constitutional protection, in that case, the right to choose a vocation, in this matter, a right to choose a profession, did not fall within a sphere of activity protected by a constitutional right available to refugees and other foreigners. And the court then said that the application therefore should also fail on that basis. It did go on, and it did deal with differentiation and with the saving provision, but it did so in addition. It did not, by doing that, say that Section 22 and the right that it creates expressly in favor of citizens is now subject to evaluation. If somebody that isn't entitled to that constitutional right comes to court and says, but I want to choose a profession. That is not at all what the Constitutional Court held in Union Refugees. So they dismissed it on that basis to say that you don't have a constitutional protection of a right you're claiming. But in any event, if we look at the discrimination you are complaining about, it doesn't amount to unfair discrimination as results of that saving provision in that applicable act. So as point of departure, therefore, judges, we say that when differentiation and discrimination and justification is dealt with, it should be dealt with subject to the express provisions of Section 22 of the Constitution, which says, firstly, we reserve a right to choose a profession to citizens, and secondly, a trade or practice of a profession may be regulated by law. But that second part of Section 22 does not undo the first part of Section 22, reservation of the right for citizens. That we have attempted in our heads of argument, our written representations to explain, is also totally acceptable within the international norm. Our learned colleague, on behalf of the first intervening party, in passing said that this is an unusual provision in the Constitution. I don't think that is fair. There are numerous exemplary constitutions that reserve choice of trade, occupation, and profession for citizens, as the Constitutional Court established.
At that point,
am I no longer protected?
No longer protected.
Thank you, Justice.
Please continue.
Thank you, Justice. What Chinooka makes an important or establishes an important principle, which we respectfully submit, and we do so with empathy, because I think that everybody on a personal level has empathy for the applicants in this matter. But what the court said there, and it was upheld by the Constitutional Court, is that to limit the fulfillment of one's ambitions is justifiable in terms of Section 22. So the moment that we get to a point where we say you cannot earn a living in South Africa, then we have a problem that is not countenanced. This court has made it very clear. But when we talk about choice of profession for fulfillment of one's own ambitions, that may justifiably be limited in terms of Section 22, which we respectfully submit the LPA does. It regulates the practice, and it limits that the fulfillment of these applicants to not being able, before they meet the threshold citizenship or permanent residency requirement, they can unfortunately not be admitted as legal practitioners. Which brings me to the next pertinent question, and which I anticipate it has already been raised, and it should be raised. It is so that the applicants entered the country. Some of them, of course, were here for a period of time, not legalized, but at this stage, it appears that all of them are here with knowledge and of the Republic, of the government. Some of them obviously have the challenge that the special exemption permits have lapsed, but there's a grace period within which they must do the necessary. They have been allowed to study at universities. They have been allowed to do vocational training. When we look at the LPA, then we see that the LPC doesn't have an election not to register a contract just because a foreign student has been able to enter into a contract of articles with an attorney firm. It is unfortunate that none of the attorney firms that feature in this matter has actually informed us or the court with regards to how they went about when they procured the services. But be that as it may, the facts are what they are. A foreign national who elects to pursue vocational training, elects to study a degree and to then pursue vocational training, of course, does so subject to the conditions of his visa. And we know that a study visa entitles a student to work and to do vocational training, but he also does so subject to the LPA and its predecessors when they were in force and the Constitution. But it's not a matter that they do this and there is no advantage to the person. Firstly, justices, in doing the vocational training, the person is enriching himself. He cannot, in terms of the reservation of the profession, take that final step, but he is qualified to be admitted if he satisfies the requirements to become a permanent resident or even a citizen. Then he has already gone through the vocational training. Secondly, he can work in the legal sector. And by doing the vocational training, he is putting himself in a better position but somebody that hasn't done that with regards to being gainfully employed in that sector. I mean, I'm not sure whether it was Justice Kulapen that made the point with regards to the LPA. Its predecessors did contain provisions that regulated the situation when somebody was admitted but no longer complied with the initial requirements. And when one reads the LPA in its current form, it does not appear that there's a specific provision therefore. That is so. We have also looked at that. We do, however, submit that the LPC would be able, in terms of Section 31A, to approach a 1A, to approach a court if an applicant was admitted but no longer complied with those two requirements. There's nothing in the Act that suggests that it cannot be done, but it is so. The Act doesn't contain an express provision as the predecessors did. Justices, the last point I just wish to make is that when one listens to the arguments on behalf of the applicants, then one realizes that the point that was made in Union Refugees, where the applicants expressly foresaw reliance on Section 22 for obvious reasons, the court remarked there, but whether you rely on it or not, it is and it remains a relevant consideration when we are talking about choice of trade, occupation, or profession. And here we respectfully submit that it is, at the end of the day, also the result that follows. So whether there is valid criticism or not with regards to people being allowed to study, which I don't think can be criticized, and to pursuing the vocational training, it doesn't change the fact that the LPA is constitutionally valid because it complies with Section 22. And the fact that it extended certain rights to permanent residents does not detract from that. We know in South Africa, in our law, we have a very definite distinction between citizenship and permanent residency and other temporary residencies. And it has been well established, I think, in the Constitutional Court that permanent residents are entitled to a lot of benefits and rights, even though not this one. The fact that they are included due to their specific status doesn't detract from the constitutional validity and our respectful submission.
Mr. Snellenberg.
Justice Kulapen.
Sorry, after you, Justice Berlanga.
No. Go ahead.
Mr. Snellenberg, just one question from my side. I mean, the choice of a career and the choice of a profession is far-reaching in the trajectory of the life of virtually every person.
Yes.
It determines the quality of life you would live. It determines whether you'd be able to live in dignity.
Yes.
It goes to your self-determination, and it goes to your ability to achieve your potential.
Yes.
And while the LPC may not be responsible for the legislation that is in place, ultimately it's a product of Parliament. The reality that the LPC may be registering contracts of articles in respect of young people who have no real hope of being admitted to the profession. In the case of an asylum seeker, they would have to wait for 10 years after they get refugee status. So on the part of the LPC as the custodian of the profession, have you not, and you may not be bound by this ultimately, but have you not created an expectation that something will follow from the conclusion of your contract of articles? I mean, often in court when we do admissions, if someone has concluded their articles even 2 or 3 years ago, the court is bound to ask a question: why has there been such a delay? Have you kept up with the law? And so for many of these people, waiting for 5 or 10 years might not be a solution, because a court is bound to raise questions. Well, are you still in touch with the law? Do you remain fit and proper from the perspective of the skills you gathered?
Yes.
Surely the LPC must have given some thought to this, and if they have, what is their thinking around this?
Justice, a fair question, firstly, and I'm going to answer it as best I can. Our colleague from Pabasa explained to you how they see it and how they, out of a globalized approach, take in pupils and have him do the vocational training. And I understand that is the incentive. Our bar looks at whether the person will be able to be admitted and then gives a person the choice. And obviously that is taken into consideration. But when we talk about an expectation, Justice, and I say this with empathy and sympathy, it could never be legitimate if we accept that the person does it subject to the laws of a country and the constitution and his study visa. I accept that one will obviously have young people that start with their career, they start studying, and they might not take the time to immediately look at all those requirements. But expectation must be legitimate, and where there's an express provision that is going to create a bar initially, then the expectation can't be legitimate. But I say again, Justice, if they have completed successfully this course, and I think what the applicants stop short of saying is that many of them had an expectation to actually qualify for permanent residency, but for various reasons that has not materialized. They would have been entitled to be admitted, and the vocational training would have been a fruitful adventure for them. So I think there's more expectations relevant here than the applicants care to admit, and I understand why. Justice, that is, we accept readily what you pose to us. That is, it is also a fact, but we do not, and I say this again with respect, I do not consider it to be a legitimate expectation.
Are those your submissions, Mr. Snellenberg?
That's my submissions. Thank you very much. Excited if there's more.
Mr. Snellenberg, I wonder if I could just detain you for a moment.
Welcome,
what was the rationale, as far as you know, for extending the right to be admitted to permanent residence and not confining it simply to citizens?
This is, I'm unfortunately not in a position to really address you on that, seeing that that's actually a policy consideration when this bill was drafted. My inference, or our inference, is that based on the approach by our courts, the Constitutional Court in particular, with regards to the rights that attach to people that have qualified to attain that status of being considered a permanent resident and being a few years away, maybe shorter from obtaining citizenship, that might have played a role. It has previously been included in the admission criteria. So I would assume that based on those considerations, it would be retained.
Well, I think it's reasonable to assume that it's because of an appreciation that permanent residents have a strong connection to the country.
Yes.
Let me then put the same question I put to Ms. Moroka.
Yes.
If there are persons in categories who have a similar kind of connection,
yes,
say a refugee who comes from a place where there is absolutely no prospect of returning,
yes,
and have made their home in this country, why are they to be treated differently in a constitutionally permissible way?
Justice, they and their rights form a subject matter of, firstly, the Refugee Act, which govern their protection and their residence within the country. And there is no attack with regards to, unfortunately, speaking on behalf of myself, the length of the period of time that they must remain in the Republic before they get certain rights. That's something different from somebody that has come here and has qualified for permanent residency. The moment,
but why is it different? Because if those persons who are admitted into this country as refugees, yes, theoretically, if conditions in their home countries change, they might and would have to return.
Yes.
But from a de facto position, they are in exactly the same position as a permanent resident.
Judge, some of them, surely, but not all of them. And I think that's one of the issues. We know that if you qualify in terms of vigorous requirements in the immigration laws to become a permanent resident, that the matter of permanency has been established. Refugees, unfortunately, and I don't know, I do not take issue with the submissions that our learned colleague made with regards to the fact that they are generally marginalized and so forth. But they are in a different situation. And the ambit of Section 22, unfortunately, do take away the right of choice. Whilst
No,
they may
the difficulty is that 22 is not a section that protects permanent residents.
Yes.
Once you extend the right of admission to permanent residents, then the question arises as to whether you thereby discriminate against people who are in effect in the same position.
Yes, Justice, I don't think, I say this with respect, firstly, that's the case that one was called to meet, but I don't think that the fact that there's an extension to permanent residents equates to it being unfairly discriminatory against other classes of temporary residents, even if they are in the Republic for a long time.
Thank you.
Thank you, Justice Interrupter.
Thank you, Mr. Snellenberg. Mr. Mazibuko.
Thank you, Justice Madlanga. We will be brief in our reply. As far as the submissions by the Minister of Justice are concerned, we wish to make two submissions. There is an issue of importance which arose when Justice Chikli was debating with my colleague, Mrs. Moroka, relating to persons who are admitted in foreign jurisdictions as legal practitioners, as to why they are worthy of admission and the ones who studied here are not. And the justification that was advanced in argument was that, at least in relation to those people, there are regulatory bodies in those countries would have vetted them. And I presume that that is for purposes of security and accountability. However, in relation to the persons in the position of Mr. Rafoneke and Ms. Trinyani, we submit that the concerns relating to security and accountability are addressed and do not arise because they have underwent practical vocational training. And it is important in their case to note that they, in fact, at a stage, brought an application for their admission in the Free State High Court, and that application was dismissed only because they are neither citizens nor permanent residents of the Republic. And the court found that they had met all the other requirements except that one requirement. It then follows that the court had found that they are fit and proper persons. Now, the judgment of Union of Refugee Women has correctly so been topical in this matter. And in paragraph 39 of that judgment, when this court was assessing the rationale behind the differentiation between citizens and permanent residents and all other foreigners, the court found that the Security Act was designed to limit eligibility for registration to people whose trustworthiness can be objectively verified. Now, that is what is important, whose trustworthiness can be objectively verified. Now, we know in terms of the Security Act, Section 23(6) has an exemption clause, and if a foreigner can objectively satisfy the regulatory body that there are good reasons for the deviation from the original position or from the default position, then such a person can be registered as a security service provider. Now, in the case of Rafoneke and Tsunyani, we submit that the fact that they underwent a practical vocational training without any problems, without any incident or negative incident, that proves that their trustworthiness can be objectively verified. They are fit and proper persons, and the Legal Practice Council can be able to regulate them for as long as they are in the Republic. So that is the first point. The second important point is that in argument, a pertinent and direct question was asked of our colleagues as to what the justification is for this differentiation or the preclusion of foreign nationals. We submit with the greatest of respect that that question was not answered, and that is telling of the lack of legitimacy in the impugned provisions. And as far as the submissions by the Legal Practice Council are concerned, the high watermark of the Legal Practice Council's case is that Section 22 reserves the right to choose vocation and trade to citizens, and that should be the end of the matter because obviously the applicants are not citizens and thus not the beneficiary of that section. As far as that is concerned, as persuasion, the Supreme Court of Appeal in Somalia Association versus Limpopo Department of Economic Development, and that is on paragraph 39 of that judgment. The Supreme Court held, and I just want to read this portion just to make my point. The approach of Rancho J in considering the constitutional right to dignity as against the constitutional right of citizens to freely choose their trade, occupation, or profession, and then holding that Section 22 is the decisive provision of the Constitution, is also fallacious. There is no trump card when constitutional rights are considered alongside each other. And this goes with what we were saying earlier, that although we accept, as we must, that Section 22 limits the right to choose trade and occupation to citizens, and that trade may be regulated by law, when the state regulates the practice of trade, it must still do so in the manner that is consistent with the Constitution. By way of an example, when the state employs teachers, the state cannot say in terms of Section 22, we have the right to regulate, and we exercise that right by excluding teachers who are, for instance, not Christians from teaching in our schools. that will violate another right of the Constitution. So Section 22, we submit is not a trump card, and we submit that for the reasons that we advanced earlier, Section 24(2)(b) of the Legal Practice Act remains unconstitutional. And if there is no any other questions, Justice Madlanga, that will be our reply.
Thank you very much, Mr. Mazubugwa. Mr. Padlender.
Thank you very much, Justice Madlanga. Justice Madlanga, having listened to the debate between the learned justices and our learned friends, we have 4 points we wish to deal with in reply. The first is the unexplained and unjustified anomalies that have now been revealed in relation to the Legal Practice Act. The second is the role of Section 22 of the Constitution. The third is the question of discretion. And the fourth is the question of remedy. Now, if I could begin with the anomalies, because with great respect, what the justices have pointed out in the debate with our learned friends, very trenchantly, is the series of anomalies we submit unexplained and irrational anomalies that result from the LPA and its treatment of people falling into the category of my clients. So, as was pointed out by Justice Chikli, the law, this is an act which says if you do your LLB at the University of Cape Town and you then go home to Lesotho and get admitted there, you can practice in this country. But if you do your LLB at the University of Cape Town and you want to practice by virtue of that, by virtue of being directly admitted, you can't. And the only answer that was given to that is, well, it's a question of oversight. But how that produces oversight was never explained, because of course there's more oversight if the LPC is in control of the admissions here, and either way, there is disciplinary oversight. And similarly, there was no explanation as to why the exclusion of people in the category of my client produces immediate accountability and oversight, despite Justice Majid raising that question. Then we came to the second anomaly, the anomaly that this was purportedly an act designed to protect job reservation, the jobs of South Africans, and yet it is an act which allows people to take up the limited and valuable vocational training spots, which are essential to enter into the job market. So you say you want to keep the attorney's profession for South African citizens or permanent residents, and yet you allow non-citizens and non-permanent residents to take up valuable spots in the training, and in doing so, they don't get the benefit themselves. That, with respect, makes no sense at all, as Justice Mhlantla and Justice Collipin's questions posed. Indeed, there's a further anomaly, which was not explained. If the purpose is job reservation for lawyers, why allow people to work as legal advisors to Anglo-American or the Department of Home Affairs? Why are those jobs not reserved as opposed to jobs in the legal profession? Then there's the point Justice Collipin makes about the fact that this is an act which removes the provision about automatic loss of admission if you are no longer a citizen and permanent residence. And finally, there's the point that Justice Unterhalter's questions raised, which is this is an act which doesn't limit itself to citizens, but includes permanent residents, but excludes all ordinarily residents. Now, with great respect, when you take those anomalies on the one hand, and you weigh up the justifications on the other hand, this is an act that almost falls down to be struck down as irrational on its own terms under Section 1 and the threshold requirement of rationality before we even get to a debate about unfair discrimination. It is an act which simply doesn't hang together or cohere in relation to its stated purposes when you look at those provisions. And we submit that in those circumstances, the purposes that have been articulated do not pass constitutional muster. That then takes us to Section 22, which is the second issue, and the attempt by our learned friend, particularly for the LPC, to suggest that Section 22 somehow operates as a trump card, and we agree with the submission made. Section 22 is relevant, but it is not determinative, and it is not determinative for the reasons that Justice Unterhalter gave in his questions to our learned friends, which were never adequately answered. If Parliament is going to draw the line somewhere other than where Section 22 does, and that's what Parliament has chosen to do, then Parliament can't rely on Section 22 to immunize its choice against constitutional scrutiny. And it was never answered why that proposition was incorrect. We would commend to you two authorities which justify that conclusion. The first is the one I had in mind but didn't have a reference to when I addressed you in chief. It is the matter of Satchwell versus the President of the Republic of South Africa. That was a case about where legislation conferred on spouses of judges certain benefits. And the reference is 2002, volume 6, essay 1, a decision of this court, where the court held at paragraph 23 that inasmuch as the legislative provisions in question afford benefits to spouses, but not to same-sex partners who've established a permanent life relationship similar in other respects to marriage, including accepting the duty to support one another, such provisions constitute unfair discrimination. So in other words, where Parliament had no obligation to confer that benefit on judges' spouses, but when it did so, it had to confer it on all people equally similarly situated. A different example, one that will be familiar to Justice Matopo prior to his elevation, Print Media South Africa versus Minister of Home Affairs, 2012, volume 6 of the South African Law Reports, page 443, a decision of this court at paragraph 79 to 82. That was a provision which dealt with classification mechanisms for newspapers and magazines, and it granted a statutory exemption to bona fide newspapers, but it didn't grant the statutory exemption to bona fide magazines. And this court held at paragraph 18, no evidence was submitted that there's any material substantive difference between newspapers and magazines. In my view, the averments that magazines have a longer shelf life, are less formal, and often contain more offensive material than newspapers do and are not subject to short deadlines, do not afford a substantive basis for differentiation. Not only is the differentiation unequal, but it is also irrational. It breaches without justification the principle of legality and the right to equality before the law. So again there, Parliament need not have conferred that exemption on newspapers, but having chosen to do so, it had to confer it on other similarly situated publications. Its failure to do so was irrational under Section 1 and irrational under Section 9(1), even though it didn't need to get to unfair discrimination. And we submit that that same principle applies here, given that there has been no cogent explanation of the differential treatment concerned. Thirdly, on the question of discretion, our learned friend, Ms. Moroka, accepts rightly that discretion was an essential part of this court's ratio in Union of Refugee Women, and that must be correct with respect, because the discretion point is not only referred to in the passage I referred to earlier at paragraph 48, but equally importantly, it is referred to in this court's conclusion in paragraph 67, where this court emphasized that the scheme was not a blanket ban, but is narrowly tailored to the purpose. It is flexible and has the capacity to let in any foreigner when it is appropriate, and to avoid hardship against any foreigner. It permits blanket exemption of categories of work in the industry and permits departure from the strict requirements of 23(1)A on good cause shown. Well, with respect, that makes it absolutely clear that the existence of the discretion was fundamental to this court's ratio. That discretion, it is now common cause, does not exist here. Here we have a rigid, non-discretionary approach, no matter how much justification, no matter how much the hardship, and that alone, it seems to us, distinguishes Union of Refugee Women and renders this unconstitutional. The only answer offered by our learned friends on this score was our learned friend Ms. Moroka's point to say that the persons in the position of the applicants can do other jobs. Well, that was precisely what was at issue in Union of Refugee Women. The people who wanted to be security guards could have gone and been window washers, or they could have gone and been waiters, or they could have gone and been anything that they wanted to. They were only precluded from one narrow area of work, and yet this court held that the discretion was essential in order to render the provision constitutional. So we do submit that in light of all of this, the provisions are unconstitutional and that there is a breach of both equality and dignity. And I would emphasize that you've heard nothing on the point about dignity, despite the fact that, as I have said, to say to people, you're entitled to come to our universities and graduate with a law degree. You're entitled to complete pupillage. You're entitled to be a legal advisor. You're entitled to do all sorts of things, but you may not be an officer of the court. You may never be admitted as that because you're not a permanent resident. That is indeed an affront to your dignity, and you haven't had any meaningful answer to that either. That leaves fourthly and lastly, Justice Madlanga, only the question of remedy. On the question of remedy, our learned friend Ms. Moroka asks for the matter to be referred back to Parliament and for Parliament to be given an opportunity, if needs be, to include a discretion and so on. with great respect, there is of course no difficulty with Parliament doing that, and there's of course no difficulty with suspension, subject, and this is the critical caveat, subject to the fact that there needs to be interim reading in the meantime. Because there is absolutely no reason, with great respect, that my clients should be deprived of the opportunity to apply to court to be admitted in the 2 years at least it will take Parliament to proceed with this. And I hardly need to tell this court about the jurisprudence on interim reading in. It's laid out in this court's judgment in Amabungani and many others. And our submission is this, and it's worth stating. If this court adopts a particular formulation, whether the one we've articulated or otherwise, it will always be open to Parliament to fix that by means of legislation. This court will not be freezing in time the remedy. It will be open to Parliament to fix that and amend it at any time, sooner than the 2 years, if it likes. But the more important point, perhaps, is this court would not be opening the floodgates, because as we've, and that was the fear expressed by our learned friends, but as we've explained in our heads of argument at paragraph 15, the category of people who are affected by this is actually relatively narrow. It is, one, people who hold work visas or permits, like the ZEP permit, particularly in this case. It is, two, people in the legal profession who hold spousal permits. Now, those are people whose families live here and who on Darwood have a right to be here in every respect. And it's number three, asylum seekers and refugees. Those are the categories we're talking. This is not a free-for-all, and it's certainly not an open sesame to every person who might ever dream of studying here or any person who would come here illegally. It is three relatively narrow categories of people, and there is no basis in our submission to withhold the remedy in respect of them, because as this court has made repeatedly clear, successful litigants are entitled to an effective remedy under Section 38 and Section 172. And an effective remedy means, in this case, that our clients should be able to apply for admission and satisfy the fit and proper test. So our submission is that the application should succeed. We submit that this is quintessentially a BioWatch case, and we're entitled to costs in respect of both the High Court proceedings and these proceedings if we succeed. And we would ask for an order in that regard, including the costs of 2 counsel. Justice Madlanga, those are our submissions.
Thank you, Mr. Badlender. Thank you to all counsel. A judgment is reserved. Court adjourned.
Today's proceedings have now concluded. The host will now terminate the meeting.